All right, welcome back to Fiegel Files. I am Beau Fiegel, the strongest lawyer in Texas. I still haven't been challenged. Each week, bringing you the perfect mix of law, life, and LSU pride. Today on Fiegel Files, we're talking about justice from every angle, prosecution, defense, and the bench. My guest has seen it all, or about to see it all. Marissa Giovenco?
Yes.
Yes, okay. I should have asked before we started, but that's okay. Is a seasoned attorney and a friend of mine who's handled thousands of cases right here in Bear County, from domestic violence and child abuse to serious felony trials. She served as a prosecutor, defense attorney, and now she is stepping up to run for district judge of the 226th Judicial District Court of Bear County, Texas. Marissa has built her career on one thing, balance. She believes that real justice isn't about politics or pressure. It's about fairness, preparation, and treating every person who walks into that courtroom with dignity. From working in the Family Violence Division, MAG office, to opening her own firm, Marissa has carried the same mission: protect the community, uphold the Constitution, and make the courtroom a place where people can trust again. She's tough, experienced, deeply rooted in the service to San Antonio, exactly the kind of voice we need on the bench. Marissa, welcome to Fiegel Files.
Thank you, Beau. Glad to be here.
Yeah, thank you for coming. Are you from San Antonio?
Not originally.
Yeah, where are you from?
I grew up in Illinois and Michigan, and then I moved to San Antonio in '95 before starting high school.
Okay. Did you go to high school here?
I did.
Okay.
I went to Judson.
Judson, all right. I didn't move here till after, I moved here for law school. Where'd you go to undergrad?
Undergrad, I went up to University of North Texas in Denton.
Okay. The Eagles? The Green?
Yes.
Yeah,
Screaming Eagles.
Screaming Eagles?
Yes.
Yeah. And where'd you go to law school?
I went to South Texas in Houston.
Okay. Did you come to San Antonio right after that?
I came back to San Antonio in between everything. I always come home.
Okay. What was your first job at the DA's office?
Not this one. My first job after law school, I took at a county attorney's office in Amarillo, Potter County.
Potter County.
Yeah.
Was that Amarillo, Texas?
It was, yes.
So how big a jurisdiction is that?
Small.
It is small?
I do not know the numbers, but
Yeah.
Amarillo, the city itself, is split into two counties.
Okay.
So Randall County and Potter County, and I worked in Potter County.
And so if you were in the county attorney's office, that's misdemeanors, right?
Misdemeanor only.
Okay.
I was there about almost 2.5 years.
Yeah. And then did that bring you here?
Yes. After that, I came back home and started at the Bear County Attorney's Office. Susan Reed hired me.
Okay.
I worked for Susan Reed briefly, about 4 months before she ended her stint as DA, and then Nicola Hood, and then Joe Gonzalez.
Okay. Great. And then when did you leave the office?
I left the office in August of 2023 and became a defense attorney.
I'll go back to why, but when you're a defense attorney, did you work for yourself or for a firm?
Both, actually.
Okay.
When I left, I was working for another firm, and then I also was allowed to start my own firm and do both simultaneously.
Oh, nice.
So I started my firm immediately. So it's been around about 2 years.
Okay. And how many years have you been practicing total?
Total 14.
14 years. Okay, so you graduated law school in
11.
2011. Less than me. I'm old, man. I graduated in 10. Okay. Close. And so exclusively criminal law, prosecution and defense.
Yes. I've done a little bit of family law over the last 2 years,
Sure.
but mostly criminal.
Okay. When you were in Potter County, did you handle any variety of misdemeanors, or were you specialized like DWI or something like
No,
that?
all misdemeanors. Now, mostly what we tried, obviously, was DWI. I tried a lot of DWIs, some domestic violence cases. It's mostly what went to trial.
I mean, that's pretty universally true, right?
Right.
For misdemeanor cases.
Absolutely.
Well, I mean,
They go to trial more often, we'll say.
well, to state my opinion on why is one, the consequences are more severe with DWI convictions and family violence convictions.
Yes.
And then two, the level of proof's a little more, might be harder to, he said, she said with domestic violence,
Sure.
easier trials for defense, and DWIs, obviously, there's a lot of scientific stuff we can get into, but a little
Right.
easier to try.
Right.
Theft's pretty hard sometimes.
Right. Not as clean cut.
Yeah, sometimes they're pretty clean cut otherwise.
Right.
And also, I think the plea bargains available in other cases make it harder to have a rationale to go to trial, I would suspect.
Yes.
So.
Yeah.
Yeah.
It was quite interesting to go from a very conservative county prosecuting misdemeanors and those kind of offers that I started out being taught to come to a much less conservative Bear County, and the offers that are made here on misdemeanors, that was
Like
quite
what?
interesting. Oh yeah, very different.
How long were you in the county courts here doing misdemeanors before you moved up to felony?
Here in Bear County, Susan Reed hired me as a misdemeanor attorney, and so I worked under her reign those 4 months as a misdemeanor attorney, and then when Nico LaHood came into the office, he promoted me to felony. So it was very brief.
Within 6 months, you were already up.
Yeah, less than.
Okay. Well, here, that's actually an interesting area because I understand there's a conservative, like, liberal idea. What I tell people, too, though, when I do some criminal law still, is smaller counties tend to have jail availability and a little, in my mind, more resources, or at least resources compared to the caseload. And so that's what I've observed. I could be wrong. So it's not all philosophical, or at least what I've observed. Bear County Jail is overrun. Right. And so getting bond, convicting people of misdemeanors where they go to the county jail, just less available. At least that's what I've observed.
Sure.
Yeah.
I think that plays a part into it. I also think it plays a part that, at least in Texas, the smaller towns tend to be more conservative, and the larger cities tend to be more liberal.
Did you guys prosecute marijuana aggressively up there?
I don't know if I would say aggressively, but
relative
we did
to Bear.
prosecute.
Yeah.
No, to be honest, we gave a lot of what's called, like, up there, they called it, I've been in Bear for too long. They called it basically time served. A JSAT.
JSATs, okay. Yeah.
We didn't call it that up there. I can't remember what we called it now.
Did y'all have a pretrial diversion of some kind?
No.
Fair enough.
Don't think so.
Okay. So you, what court were you in when you got here? What misdemeanor court?
Well, misdemeanor court, when I came here, the first one was County Court 11.
Who was there?
Judge Key.
Was this his first? This is his first stint, right?
Yes.
Because then he went, I can't remember, he lost an election, he came back to a different court, if I remember right. Yeah. Mm-hmm. He's still in?
Yes, he's up for re-election.
Yeah. I'm a fan. I won't hide that I am. So I'm friends with Carlos. Okay. And then you moved up to felony. So which court did you go to first? I'm sure you've been in a bunch.
Less than you would think, to be honest. I was in the 227th first, and that was Judge O'Connell when he first took the bench.
Okay.
Yeah.
Did you so in Bear, and correct me if I'm wrong, if I understand right, the prosecutors, when they're assigned to those courtrooms, it's not a judicial assignment. The prosecutor's office says you're working this courtroom.
Absolutely.
To have continuity.
Right.
Well, actually, take a step back. Bear County's big enough. We have 10 district courts that only handle criminal matters. Is that correct?
Felony criminal,
excuse me, yes. I apologize. Yeah,
okay.
There's 24 judicial district courts. 14 are exclusively civil, and 90% of that's family. 10 courts are exclusively felony district. And so if you're a prosecutor, you get assigned to that court. But in the DA's office, if I understand right, within that courtroom assignment, X% of prosecutors are doing family violence, and the other half are doing, is it CTD, is that what it's called, or Criminal Trial Division?
Criminal Trial Division, correct.
And that's everything else?
Yes.
Okay.
There are some other specialized units, but those prosecutors are not assigned to a court.
Right.
They handle all of those special types of cases.
Like white collar?
Court. Like white collar, which is not called white collar anymore, but yes.
What's it called now?
I'm going to get it wrong, but
That's okay.
I think it's PIC, public integrity something.
Oh, I thought that was something different. Okay.
No, I think they handle all of them.
Because they do have an integrity office now that actually looks at prior convictions, if I remember right.
Right, that's separate.
Oh, okay. So, white collar crimes essentially.
Right.
What other specialties are there then?
Well, the white collar, whatever that unit is, they handle like child pornography, and then there's a unit that handles officers or people who are high up in the community who get arrested.
Oh, okay.
They handle those specialized cases.
Yeah. Okay. All right.
Unless it's changed since I left.
So have you been in the felony prosecutor role doing domestic violence or family violence, and CTD?
Yes, I started out in CTD, or Criminal Trial Division. I was there total about a year. I started in the 227th, and then I got moved to the 226 with Judge Sid Harrell.
Okay.
And then after that, I moved to family violence, and I was there mostly the remainder of my time at the DA's office, minus about 9 months where I went and did overnight mag. Okay.
When we say family violence, that doesn't exclusively mean boyfriend beats up girlfriend. So what's the definition of that? What crimes fall under that?
Sure. So family violence handled anything that domestic violence, which is any sort of family relationship, boyfriend, girlfriend, roommates, any child abuse, any cases against children, any interference with child custody, and then any sex crimes. So any crimes against adults or children that were sexual in nature.
Okay. And then the pornography stuff was handled somewhere else?
Separate.
Okay. I assume sometimes those go together, though.
They do.
Okay. Yeah. All right. Well, why be a prosecutor? You get out of law school. What interest? Why go to be a prosecutor's office?
Yeah. So I actually decided to go to law school to be a prosecutor.
Yeah.
I originally was going to be a pediatric nurse.
Wow.
And then when I was 19, I was selected for a murder trial on a jury.
Okay.
And as I came to remember much later, it was Judge Angelini's court.
Wow.
Yes.
In Houston?
No,
you were
here.
high school.
Here. I was 19. I was still here.
Wow.
Mm-hmm. Yes. So it was a murder. It was a family violence murder. Husband shot his wife.
Allegedly.
Yeah.
I'm just kidding.
No, he was convicted. I'm like, no, we're past that. He was convicted. So yeah, that kind of changed my whole life after serving on that jury.
Wow.
I decided that was what I wanted to do. Now, then through law school, I kind of fell in love with the law more, and then wasn't sure if I wanted to be a prosecutor or if I wanted to do a different type of law. And so when I was looking for a job, when I graduated was 2011, and the job market was crazy hard then. Yeah. The Bexar County DA's office was on a hiring freeze. A lot of DA's offices were not hiring. It was opposite of the problem we have now.
Yeah.
Right? They weren't short-staffed at all. And so it was very hard to find a job. So I was looking all over.
Okay.
And then it just so happened that the best job opportunity I guess I ended up getting was the Potter County Attorney's Office.
Okay.
And so I took that and moved all the way up to Amarillo.
That's a big move.
Yes.
Wow.
Yeah, it was. But I've always, I know I said I went to law school to be a prosecutor, but I've always wanted to help people. And I have always taken the oath of a prosecutor extremely seriously.
What is the oath of a prosecutor?
Yeah, the oath of a prosecutor is to seek justice, not to seek convictions. And it was always extremely important to me to look at every case individually. And, I was never afraid to get rid of a case that didn't need to be prosecuted.
This isn't just to be like a semantic exercise, but when you say to seek justice, how are you defining that? What does it actually mean when you're saying that?
To do what's right.
I don't know that it's hard to know unless you're in the system, whether working in it like we do, or you're a probation officer, something like that, to understand. But in my opinion, prosecutorial discretion might be among the more powerful tools around it.
Absolutely.
Their decision, your decision to try somebody, not try somebody, what crime to try them for, what counts. We were talking off camera about a case we'll get to in a little bit about, do you charge it separately, different indictments and such. It has an instant and significant impact on a human's life. The defendant, to some degree, the complaining witness or victim. Expand on that for me. Like, for people, your job, it's very important, and not just I put bad guys away.
Right.
But into how much does that discretion matter, and how important is it to exercise it cautiously? Oh,
it's huge. I would almost say that the prosecutor's office has more power than a judge.
I don't think that's a question. Okay. I think this is opinion, but I think it's inarguable.
Right, and I think that's shocking to people.
Yeah.
I think people think judges can do a lot more than they can.
Mm-hmm.
The prosecutor not only looks at the officer's work report and decides whether, yes, that arrest should stand, whether I should go forward or not, whether the person actually stays in jail. In Bexar County, we've got the prosecutor. Like I said, I worked at the magistrate's office for a period of time. There's a prosecutor there 24/7.
Yeah.
And an officer arrests you, you go straight to that prosecutor. The arrested person doesn't see the prosecutor, but the officer does.
Right.
And that prosecutor reviews their report and signs off on it, or says, no, you have to let this person go. And that's huge. So prosecutor decides whether or not a person stays in jail. Then they decide whether or not the case gets filed and an actual charge is there. Because once you're arrested doesn't mean you're actually being charged.
Right.
Right? The prosecutor has to make that filing decision after the arrest. And then they decide whether or not they're really going to proceed and go to trial if that is something that the defendant wants. Both sides have a right to a trial. But not only that, they make plea offers. They make punishment decisions solely on their own on what they think is appropriate punishment for someone who's committed whatever crime they're working on.
It's easy. I mean, only one, if I understand right, only one office in the prosecutor's office is elected. It's your elected DA.
Right, correct.
Right? And then the staff is hired after that, including
Correct.
all senior DAs and all, approximately how many DAs, prosecutors work in the DA's office for Bear County right now?
Oh, I would say over 100. I don't know for sure.
And this isn't a criticism in any way, but we're not talking about a very highly paid positions. Is that fair to say?
Correct.
So is it fair to say a huge number of people that work in the DA's office, this is their first job?
A good amount, yes.
A good amount. So you have 20, not always 25-year-olds, I was 25, but 25, 30-year-old kids just fresh out of undergrad law school loans to pay. Again, this isn't a mean comment, but not a lot of life experience. If they're, and this is my kind of perspective, out of law school, probably worked really hard, but also had advantages in life to get them through undergrad, get them through law school. Struggle. It's a lot to ask a 26-year-old kid to have a perspective on people with drug addiction, mental health issues, toxic relationships that lead to domestic violence, poverty, and you get a book that says, here's, Class B misdemeanor means 6 months in jail, Class A. That's a lot to ask. What training do y'all go through when you get to a DA's office, and how do you mentor these younger prosecutors who have to be deer in the headlights, have to be, or like super, I'm going to be super prosecutor to go, like that's a human being on the other side.
Right.
How do you manage all that?
Well, I mean, that depends on the DA and the DA's office and how they're handling their training. My first job, I really did not get training. I got thrown in, and that was majorly deer in the headlights.
Yeah.
Now I was asking coworkers who were around me, like, what should I do? What should I offer? But that was in Amarillo, so those were much higher offers. And then I came here, and it just depends on the structure and the training and how the office is set up. I've gone through different stages of my career at the DA's office when I was there, when sometimes we had a lot of training and sometimes we had no training. You just kind of have to try to figure it out on your own. Ask your coworkers who have more experience than you. You just kind of have to learn by doing, unfortunately. And then I would say not everyone goes in without those life experiences. Just because if they're younger doesn't necessarily mean they didn't have that.
Absolutely true and fair.
Right.
Yeah.
So some do, some don't. But every prosecutor is different, and every prosecutor is going to look at a case differently.
Yeah.
Some may be similar, but each person takes their own experiences and their own opinions into each case, which is also dangerous.
So, because I don't want to frame it like the job itself, if it was only a bullet point puzzle piece test question of does the actions of the alleged defendant meet the offense, did the police investigation go appropriately, is the evidence legally seized, can we prevail, and what is the punishment range? That on its own is hard enough,
It
right?
is.
But add in the element, I would speculate to say most of the cases that make it through MAG are appropriate to be filed. They're a high percentage. I mean, things fall through or bad things happen, but or it's not up to you maybe in the MAG's office to say we're dismissing that. Maybe the defense attorney finds a problem with a warrant later, but a huge percentage. But now it's left to you in the courtroom to be like, what plea is appropriate? Just because I can seek 10 years in the third degree, just because I can seek a conviction, or are we talking about deferred, or are we talking about pretrial diversion, or this isn't a case we need to try because of circumstances? That human element, I think, is a huge responsibility, and I would imagine be hard. I mean, did you find that hard? Did you find that challenging?
Yeah. Oh, absolutely. It's kind of hard to, especially on a felony case, to kind of figure out a number of years that's appropriate for someone to spend in prison for what they're alleged to have done.
Yeah.
Right. And you're kind of just, I don't want to say making it up, right? You use some experience, and it changes as you get more experience, especially trying cases. You see more what a jury thinks is appropriate. And so you kind of use that to base what your offer would be. What we would look at least what I would look at in making a plea offer, would be what I think a jury would do. What happened, first of all? What crime are we looking at? What I think a jury would do. Can I prove my case beyond a reasonable doubt? What the victim wants to see happen. That's something that we took into consideration.
Mm-hmm.
And then the defendant and the surrounding facts, and maybe things that any mitigating factors that went into the defendant's life and what got them there.
I think this is where like news stories might make your job even harder, because I would imagine, let's just make it very extreme polar cases. You have a minority person gets assigned whether it's a public defender or in our case an appointed attorney. They don't make the money private attorneys do, candidly. I respect a lot of my colleagues, but not everybody puts in 1,000,000% effort in that instance, and they take a plea with maybe not understanding everything. It happens fast. Then you get white kid gets, a major, I don't want to say names, a very high profile attorney, and not just high profile, like it's manipulating the system, but that attorney takes the time to do, like, I call them good guy kits. Like, when I talk to a prosecutor the first time, especially with a case that might have some mitigating factors, here's who this person is. Like, I bring you aside, we talk in the courtroom, they have 2 young children. This is what was going on in their life at the time. They made this mistake. Here's the classes I told them to take already. They are in AA now, or they are doing this, and I present that to you and give that. But already, like, these 2 people could be the same except for resources available. But who gets blamed? The defense attorney on this side did a better job or gave you more to work with, and you give a lighter plea negotiation or pretrial diversion. It doesn't happen over here, but now you're racist or you're this. Like, right. That's got to be a tough position to be put in, I would imagine. So,
yeah.
You talked about victim input. For people, basic, what rights or roles do victims have in these criminal cases for the police office? Well,
the victim has a right to know what the plea offer is, to understand why the prosecutor is offering the plea offer, to know anytime the plea offer is changed, reduced. The victim has a right to know that. The victim, I always told the victims that ultimately it was my decision what the offer was, but that I would absolutely consider what they were looking for.
Yeah. I think people sometimes, there's a term in pop culture like, I'm pressing charges.
Right.
Can we agree? It's not a thing.
No, that's not a thing.
You could press charges as a DA.
Well, I used to, right?
Right, yeah.
Yes.
In that role.
The state of Texas is pressing charges.
Yeah. So
there's no one person pressing charges against another. The only time that ever happens is in civil, right? Yeah. When it's a civil lawsuit. Otherwise it is the state of Texas versus the defendant, person accused. So people keep saying, well, I didn't press charges, I want to drop charges. Well, that's not a thing. Does it help if you tell the DA that you want to drop charges? It could, but it doesn't mean that the DA is going to drop the charges.
Well, this happens the host in domestic violence cases, right?
A lot.
Yeah.
Yes.
I get
absolutely.
That they come to me, and sometimes harrowing circumstances. Sometimes it was one bad night and one fight. Someone called the police, and I try to explain to the clients, like, that domestic violence is a rampant problem. They can't just take this person's word for it that they don't want to proceed. How many people are being coerced into that? Or, I don't know what the vocabulary is, but they're in that cycle of violence, and it's just going to happen again. Right. DAs know that. Judges know that. So, yeah, it's a tough place to be, for sure.
There's a good mix of where it is a cycle of violence, and then there's a good mix of where it got blown out of proportion and nobody really needed to go to jail. But if you call the police in a domestic violence situation, at least in Bear County, our police have to make an arrest if they believe that domestic violence occurred. Now, the DAs don't have to go forward, but the police have to make an arrest.
And make it worse, unfortunately, there are people who know that and manipulate that system.
Yes.
I do a lot of family cases. You've done some, and that happens, and they abuse CPS, and again, putting you in a very difficult position in that case.
Right.
What was maybe 1 or 2 rewarding memories you have? We'll get to that case we're not going to talk about. What are some rewarding memories you have in the DA's office? You can go anywhere. It can be from the early ones. It can be a nasty felony. It could be someone you gave pre-trial diversion and they're thriving now.
Sure. putting me on the spot on that one to use my memory. I will say
we can edit the time thinking.
Yeah,
so
no. I will say there, maybe ironically, I had a case, an adult sexual assault case, that we tried, and we fought for this woman who we obviously believed that she was sexually assaulted.
Pull the mic a little bit too.
We believed that she was sexually assaulted. Because I wouldn't go forward on a case that I didn't believe happened, right? I wouldn't try to prosecute something if I didn't believe that it actually occurred.
I think it's important pausing there. I've had experiences where I'm not sure I believe that's true with some of my colleagues on the other side. So that is very refreshing to hear, and I think important when you're campaigning for judge, and we'll get there. Just because someone says it, if you can't prove it, I would argue, but I want to ask the question, do you think you have a responsibility not to proceed if you can't meet your burden?
Absolutely.
Yeah.
Absolutely. Ethically, I think you should not proceed on a case that you don't think you can prove, or if you don't believe the person is telling the truth.
Yeah.
I mean, I think that's astronomical. I think it's huge. If you don't believe the alleged victim, then you shouldn't be prosecuting a case.
That seems obvious, but
it's not.
But it's not. I'm sorry to interrupt, but that's an important distinction. I think.
That's okay. Yes, and we did. We went forward and we went to trial, and we did not prevail. We lost. The defendant was found not guilty, and that victim still, or at least alleged victim, right? It was the guy was not convicted.
Sure.
Really thanked us for fighting for her, and so that was something that was kind of heartwarming, I guess. Make me feel good that even though she wasn't mad that we lost, she was just happy someone believed her.
Did she have to testify? She
did.
That's got to be harrowing.
Yeah, it's hard.
Yeah. For people who don't know, it's said, you might know, but like the burden in criminal cases on the prosecutors, it's thrown around, but it's beyond a reasonable doubt and working against a presumption of innocence. Right. So in theory, the defendant walks in there, 5 touchdowns ahead, or however, whatever metaphor you want to use, you need to have it locked. My experience in practice is it's pretty hard on defendants. Now, once you're there, something probably happened to at least get you there to at least do it, but it's a high burden.
As a defense attorney, I'm surprised you say that. Something probably happened for the defendant to get there, because I feel like that's the way our juries think, but that is not the presumption of innocence. No,
I don't say that in court. I mean, in general, like something happened and you're like, I don't know how many times I've seen people full on falsely accused, like in absentia. I'm living in San Antonio and some person at Tyler says accusing me of murder. I've never been at Tyler, right? Or something like that. That's what I mean by that.
Okay.
There are circumstances surrounding that you are in a bad situation that get there. Now, I don't mean you're probably guilty by sitting in that chair.
Right.
I mean, no, you're already in a rough spot, and you'd be put in a tough place. And I don't know. And I mean, cases in my life is the defense got the wrong guy. Most defenses are.
I've had it happen.
Have you?
Yeah, a handful of times when I was a prosecutor and as a defense attorney. My first hired client as a defense attorney was a complete wrongful arrest.
Really?
Mm-hmm. And I've had it happen as a prosecutor too.
I know I'm not trying to give names or trying to scare, but what kind of case would that happen in?
So the one that I was a defense attorney on, my first hired client, he is actually a teacher here in Bear County. And he was arrested. I don't remember what county it was. It was some small county outside, not anywhere near us. It was a couple hours away. Mm-hmm. And I don't remember. I'd never heard of it before. Yeah. And he was arrested for a harassment. A woman was accusing her ex-boyfriend of harassing her. And this client hired me, and he's like, look, I'm married. I have never heard of this woman. I've never been to this county. I have no clue what they're talking about. And it turns out that the person who she was accusing had the same name, same date of birth.
So it's John Smith, but the wrong John Smith.
Sort of.
Wow.
Yes. Very similar name, date of birth, everything. I think the only thing different was maybe the middle name. Something was slightly off, but otherwise it was extremely close. So he got pulled over, got arrested, went to jail, had to pay a bond.
Oh, man.
He had a friend of his who doesn't do criminal law who started the process, who took a picture of his ID and sent it to the DA. They did figure out before I got hired, because she referred me.
Yeah.
They said, yeah, it's not him. But because it was this small county and the way they do things, after I got hired, it still took me 3 months to get the case dismissed, which is absurd. In Bear County, it would have been done very quickly. But because of this county, they told me they had to mail the paperwork to Austin, wait for it to be filed, then mail the dismissal to Austin.
Oh my
It was
gosh.
like crazy. I was like, this guy's going to lose his job.
How long-
Thankfully, he did not.
How long is this expunction going to take?
I did his expunction.
Did you? Okay,
I
good.
did, yes. So we got it expunged. And thankfully, he didn't lose his job in the waiting process, but it took like 6 months.
You're running for judge. You may not want to answer us, but do you have any memories you regret? A case you handled poorly, a case you wish you'd have done better, anything like that? And if you don't want to share that, that's fine. I don't put you on the spot. Or a lesson you learned.
Oh, I've learned lots of lessons.
Yeah.
That I don't even know where to start on how many lessons I've learned.
Yeah.
I don't know that there's anything I can think of off the top of my head that I'm like, oh, I really didn't do that.
Okay.
Yeah. Yeah, nothing. I mean,
Yeah.
Yeah.
That doesn't mean
sure.
she's perfect. Just
Right.
like,
I'm definitely not perfect. I'm sure I've made mistakes, but nothing I can think of at the top of my head that I'd like to share.
I presume a lot of like in trial, like, oh crap, I didn't object, or
definitely.
oh, I let that in, or that happened, or
Absolutely.
Yeah.
Absolutely.
I don't know. One of the weirdest part about our jobs, in my mind, is everything is at a glacial pace, and then you get into trial, and it feels like it's times 2,000. Like
you're very much thinking on your feet.
I'm a pretty bad ADHD, and I can't sit still. I got to have like my phone open and listening to music while I'm eating, while I'm cooking, doing this. Trial, nope, I'm locked because there's enough going on.
Yeah, it's trial brain. You're doing three things at once already. I did just think of something that I messed up in trial, without giving too many details.
Sure, yeah.
We had a case where the guy made a partial confession, and I failed at getting his partial confession admitted.
Was it an evidentiary, like you didn't know the predicate, like messed up the predicate, or?
It was in Spanish, and the officer who did the translation didn't show up.
Oh, man.
To testify. So that was the first problem. So that wasn't my mistake, right? But now I had to get creative to try to get his confession in without the translation.
Uh-huh.
And I tried like 3 or 4 different things and still failed. And so we had to move forward. I was just stuck. And I'll tell you who the judge was off air.
Yeah.
But afterwards, the judge was like, you should have done this. And I was like, and of course he was acquitted.
I had well, there you go.
You know?
I had a judge tell me, and I'll tell you later, but at a county court on a DWI, like, we objected to breath, we objected to field sobriety, but we didn't like attack the HGN specifically. And the judge, after the ruling of the testimony, was like, why didn't y'all freaking ask to suppress it? I was going to, and by the way, that's the right thing for the judge to do. It's up to the lawyers to do their job in court, but afterwards, hey man, here, let me help you out.
Sure, afterwards you could talk about it, but during trial, the judge has to stay neutral to both sides.
Yeah. And we're going to get there super quick. My last question on the prosecutor side, I want to get to the defense, is how do you avoid being cynical? And because I know I struggle with it personally. I have a cynicism built up. I haven't had a lot of content out yet, but I struggle with CPS in general. Respectfully, your former office, how they handle CPS cases, and in criminal side, I have a lot of cynicism. If we have time, we can talk into like how DWIs are handled or stuff. And I get jaded sometimes. I get frustrated, and sometimes I don't think it handles my performance like in court, but certainly I have to take a step back and not get angry. All prosecutors are the same. All cops are this. I have to imagine you give a defendant a break on drugs and give them opportunities for like rehab on PTD or deferred, and then 6 months later they're back and not only struggled like not to relapse, but like didn't even take advantage. You take a bet on them and don't. How do you avoid that kind of cynicism and keep a perspective of treating people with dignity as a prosecutor?
I think it's hard in our line of work to not be jaded on both sides.
Yeah.
I think there's different forms of, I've gone through different levels of being jaded in my career on different sides. I think you just kind of have to take a step back and remember that this is not black and white.
Yeah.
It's not. Each case is not black and white. It's not just what's on paper. Mm-hmm. We're all human beings. And that goes for everybody, right? That goes for cops. That goes for prosecutors.
Yeah.
It goes for everything. And you're going to get one cop who would create that's not what I want to say. You get one cop who would treat a situation differently than any other cop, right? Everyone's different. And same thing with a prosecutor. You get a case and you may think that that prosecutor is going to handle it a certain way. Like I know, especially me, when I switched to defense side, I would look at a case and be like, oh, there's no way they're going to file this because I would never have filed it. Mm-hmm. And then I'm completely wrong. And
sure
they
enough.
do file it and they're trying to go forward to the max. And I'm like, wait, what? So it's kind of different. And it's kind of, that's one thing that's eye-opening when I left the office. It's because when you're in the office, you do talk to your coworkers and you see something, but you don't, maybe you talk to people who are more like-minded. Mm-hmm. And there's others that you don't maybe talk to as much. And then, or you don't see how they handle the cases. And so now as a defense attorney, it's kind of like, wait a minute, you're really going forward on that? Or those are the offers, or, okay, they're more lenient than I thought, or they're more strict than I thought, or, so everybody's different, and you have to remember that. And that applies to defendants too.
So to move along, I've enjoyed talking to you, so I'll try to streamline. So why go into defense? How long have you been in the prosecutor's office before you left?
12 years.
And if you don't want to share this, that's fine. But I mean, you can retire at a certain point, vest. Like,
Sure.
Did you give some of that up?
I did vest before I left,
Okay.
which vesting means that you're vested in your retirement. So I did get that. I will keep my retirement that I had.
Okay.
So that was important, obviously.
Yeah.
The other thing that I took into consideration was the public service student loan forgiveness.
I was wondering if that...
My loans were forgiven. I
you
left
go.
shortly thereafter that. There was a lot that went into my decision to leave. It was not an easy decision.
Yeah.
It was a hard decision. I mean, it was 12 years of my life to all of a sudden change.
And your adult career. I mean, that's
Correct.
what you've done.
Correct. And, I like standing up and fighting for the children who can't fight for themselves. That was probably the biggest thing that I enjoyed about being in that unit, was fighting for the kids. I love kids. I don't have any of my own. And it was something that, I felt strongly about.
Yeah.
But I think sometimes, I don't know if this is the same anymore, but defense attorneys used to get a bad rap. How do you prosecute those people? How do you defend those people? Mm-hmm. How do you sleep at night? How can you get people off who are criminals, right? Well, everyone deserves an attorney fighting for their constitutional rights. Yeah. That's something that people need to remember. And that what if it was you, or what if it was your family member? You would want somebody fighting to make sure their rights weren't violated. So I don't feel like it's that different, if you ask me. Like, I'm still helping people. Just like I was as a prosecutor.
It's funny you say that because, as you're saying, standing up people can't fight for themselves. I think most of my bars, that's what we do,
Absolutely.
Right? What are you talking about? That's
Absolutely.
our role, right?
Well, it's just different, right?
Of course, yeah.
They're both people who the victims can't really fight for themselves either, because they can't. They're not the attorney, right? Yeah. It's the same thing. And so I wanted the experience as a defense attorney, and I think it's important as someone who is running for judge to have been on both sides.
Was that an aim of yours when you left?
Yes, it's been an aim of mine for a long time. It is something I've always wanted to do. Yeah. And I wanted to make sure that I was on both sides before I ran.
Well, what are some of the differences? What have you learned that you didn't know? You've 12 years prosecutor. We talked off camera. I think you tried 50, 60 cases, first-degree felonies, in the office while they're trying capital stuff. I mean, there's always more people more knowledgeable, but you're an expert. You're an elite prosecutor. I'm just sucking up, but I mean, for real, at a certain level, only so many people know that are in the era we are, right. And you're one of those. But now you leave what you know.
Right.
So what have you learned as a defense attorney that you didn't know? I had that wrong, or my eyes are open to this.
Sure. I would say, I guess as a prosecutor, I never fully thought, everything in this police report is true. I was not one of those true believer. That's kind of what we call him, right? A true believer prosecutor.
By the way, I'll affirm that. I know this person. I don't know. I think we had 5 or 6 cases together. Not a bunch.
Right.
But you were ones thank God Marissa's on it. Cool. Anyway.
Thank you.
Well,
I appreciate that.
And I don't interrupt, but it matters. And again, to my colleagues that maybe do hear this with my dozens of listeners right now, but the relationship between us is a huge. It is significant in the administration of justice on your side, and how we can work together, how we can coexist, keep courts efficient. I know on the civil side for sure. I'm I know that guy. Is that a problem? No, you like that. Your bill just got cut in half because We won't play games on settings. We'll confer. We'll be upfront with each other. And that doesn't mean if I've got a horrible, someone accused of the case we're about to have, a horrible child torture, and your other side, as a human being, I'm not supporting this stuff. And I know as a human being, you're not, if I know that you are not prosecuting in bad faith, I know that you are being upfront about Brady evidence, I know you are being sincere with this is the offer I have to make within my job, then it's so much easier to coordinate. I think I got off topic, but
and on the defense bar, or on the defense bar and the criminal side, I should say, I think for the most part we get along on both sides.
I think so.
For the most part, we work well together. There is a saying, I think some defendants worry when you're talking nicely and laughing and joking, or maybe just cordially talking to the prosecution, but you catch more flies with honey.
Yes.
If I go in and I'm being angry and yelling at the prosecutor, they're not going to give you what they want or what we want, right? They're not going to, So it doesn't mean just because I'm being nice to a prosecutor or the state in general that I'm not doing my job and fighting for my client.
Well, we already talked about, as a prosecutor, I know as a felony prosecutor, you have a wide range of discretion, but you still have a boss. The elected DA sets the parameters for pleas, and you know your discretion, and when you have to go above a level up, be like, I'm considering dismissing this, or I'm considering doing this, or I'm doing something outside what a norm you would be. I need to rationalize this. So you've got bosses too. It's not just you being malicious, and you're not the person that accused the person of the crime. Right. So, you got a job to do.
Right. Absolutely. Yeah. No, it's true. And we did get off topic. I don't know where I was going now.
I apologize. I said what lessons you've learned on the defense side.
Oh, okay. Yeah. So I was not a prosecutor who was a true believer as a police report, but I think that I have seen more cases where I'm like, this police report is absolutely not what happened. So I think that's kind of opened my eyes a little bit more as to okay, we really need to watch these videos. We really need to pay more attention, because I'm not saying that the police are lying per se. Maybe some are, some aren't, but they may have remembered incorrectly, or they may have, everybody's memory and perception is different. And so they may have perceived it one way, and then you watch it and that's not what a jury is going to perceive, right? Yeah. That's not the way it looks like it happened. So it's really important, especially on the defense side, to really watch those body cameras and see what really happened. It
is a very human thing, because when you're a prosecutor, even, I don't care how objective, neutral you are as a person, you are reading to do your job to an extent. And that doesn't mean you're reading to prosecute. Even if you're trying not to look through that lens, you are looking through that lens. Mm-hmm. You work with these cops every day. Yeah. And so and when you're defense side, you are reading to poke holes. Right. And just that perspective change alone, it's crazy. We can read the same thing and see two different things.
Right, absolutely. Yeah.
How long have you been a defense attorney now?
2 years in August.
Okay.
So a little over.
Have you been able to try many cases as a defense attorney?
I have tried 3 as a defense attorney, mm-hmm. and 3 or 4 in family law jury trials.
Jury trials in family law. How was that?
Interesting.
Yeah.
Totally different.
It's weird when you have to write your own jury charge, and
I haven't had to do that, but I've also sat second chair. So,
okay, yeah.
So there's that.
My retainers on criminal jury versus family are 3 to 4 times. They're like, why? Because we do everything on the civil side, and this is dorky. No one wants to hear this, but and the criminal, if I remember it, the court, a court staff will give you a proposed jury charge, mm-hmm. and then you object from it.
Correct.
You both do that there.
And not all counties are like that.
Really?
Some counties you have to write your own. The prosecutors have to write them.
Yeah. Mm-hmm. I try to be in a position now where I write a proposed one no matter what as defense attorney. Okay. It doesn't always go well. Most importantly, it prepares me for the objections I might have later, or mm-hmm. adding a provision or something like that.
Sure.
But yeah. All right. So when did you? I know you said you've been aimed for the judge, but when did you make the decision that I'm going to run? And why this election? Why this court?
I don't know that I have a sophisticated reason of why now. It just kind of felt like the right time. I did sort of run before, not in a full election. There was a special election when Judge Olivari passed. Okay. And I was in that. and I did not stand a chance, which was fine. I
Was
had
that-
a little bit of experience.
Did you run in the primary or the general?
Neither. It was a special election. So Judge
Then-
Olivari passed. He passed after the primary, but before the general.
Mm-hmm.
And so only the Democratic precinct chairs could vote.
Okay.
And so I was only campaigning to them.
Oh, okay.
And it was when Judge Mary ended up on the ballot. He won that special election that I was in.
For those who don't know, Judge Mary had been a civil judge for 3 terms. I mean, quite a while.
And he was a misdemeanor judge before that.
I didn't know that. Yeah.
Yes.
And so,
So
I mean, there's no shame in losing to that level
absolutely.
of figure.
No,
Yeah.
he'd probably known those people for years. He definitely is very well respected. And,
Sure. Yeah.
Yeah.
Okay.
And he had a runoff with Therese
I don't know.
Hunsinger.
I don't know. I thought Olivari's seat was taken by Judge Castro, but I might be wrong.
No.
That's just a different court entirely.
Mhm.
Okay, that's on
Yeah.
me. So
That's
yeah.
okay.
Maybe
Judge
it's the same-
Castro's 399. Judge Mary took Olivari, which is 144.
you know what I think? I think maybe the court rooms were the same, or they got moved, and maybe that's why I'm confused.
Yeah.
So
Yeah.
I go to the same place, but the
Yeah.
number's different.
And so, I mean, I'm glad I didn't win that. I wasn't ready.
Yeah.
It wasn't right. I hadn't been a defense attorney yet. Like, a lot of things have changed.
Yeah.
And so I knew this election was coming up. I knew that this bench would be open, which means that the current sitting judge is not running for that bench. And so it just felt right.
Who's the current sitting judge?
Judge Ben Robertson.
Okay.
He was appointed by Governor Abbott when Judge Velia Mesa won her election for the 4th Court.
That's where I was headed. And Judge Robertson didn't want to run. I actually don't know.
He is actually running for a civil bench.
Oh, okay. He took an appointed seat in the civil side.
Correct.
And I forgot what judge he...
73rd, Judge Martinez. Elizabeth?
No,
73rd.
Judge Canales. But Judge Canales stepped down.
Oh, yes.
And took... he was... I don't care to say it. He was wonderful. The 5 times I was in front of him.
Judge Robertson?
Yes.
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 I've heard
Again,
good
I only had
things.
family members in front of him, family matters in front of him. He did something that, I'll just frankly say it, he applied the law to the facts. And when he gave his rulings, he goes, here's the legal question, here's my very short analysis, and here's my ruling on A, B, C, D. It was so clear and coherent. Whether he ruled for me or not, it was like, it just felt very succinct. Like, okay, here's my job, I'm doing my job, and I'm done. I haven't been in front of him on the criminal side. So he's currently sitting there. Where are you at in the election? Are you in a primary side, or are you in a general right now?
The primary is in March. It's March 3rd with
Okay.
early voting February 17th through the 27th.
How many opponents do you have?
1.
And who is your opponent?
Her name's Anna Ochoa Nelson.
Okay. Do you know Miss Nelson?
I do. We used to work together.
Okay. Yeah. And again, I know you're not going to say anything negative or nasty,
No.
but make your case. Why vote for you over Miss Nelson, who I do know?
Sure. I mean, Anna and I work together. I don't have anything bad to say about Anna.
Mm-hmm.
The reason why I would suggest that you vote for me over Anna
Yeah.
is that I have been on both sides of the courtroom. I have practiced criminal defense. Anna has only been a prosecutor.
Yeah.
She has solely, her whole entire career has been focused as a prosecutor. And she has been a prosecutor for 11 years, and then I've been an attorney for 14.
Okay.
So I just have more experience.
Yeah. What the question Ashley, my social media girl, wrote was, now you're running for judge, what's the core principle you'll bring to the bench based on your experience? I don't know that there's one, but what are some principles you want to bring?
I mean, kind of one thing I've been campaigning on is that I'm running to bring humanity back. I think we've kind of had this, the way we've been talking, I hope you can pick up on it, is that I want everyone in the courtroom to remember that this is a human being that we're dealing with. And that's something that if I'm on the bench, I can help control. That everybody in the courtroom will be treated with respect, regardless of if it's the attorney, the victim, the witness, the defendant. Everybody will be treated with respect. I also think we need to not just look at what's on paper. We need to ask questions. I need to know what got us here. How can we help this person, if that is appropriate, to not come back to the courtroom?
Yeah.
Right? This is supposed to be, yes, there is a punishment element to the courtroom. Obviously, it's kind of like, I've always said, even when I was a prosecutor, it's kind of like a parent with a child. If they do something wrong, you have to punish them, but that doesn't mean that they're a bad person. And you also want to punish to ensure that they don't do it again. There's a lesson that needs to be learned of how, why this is wrong, why that's not something they should be doing. And so sometimes that means let's get to the root of the problem. How did we get from point A to point B. What did we, what happened that made you take this route? And how can we help them? How can we fix this? How can we get this to where you're not coming back to my courtroom on a regular basis or to any courtroom? And so that's something that I have seen done in some courts here in Bear County. And, those are, without naming names, but those are some judges I highly respect, that when you see that they are truly trying to make a difference in the community. And that's something that I aspire to do.
And a difference within the bounds of your role. And I think for people to maybe outline we made the comment before, prosecutors have more power. Sure. I believe that, I believe that in the extent of the judge can't adjudicate anything not before it, and you can make that call. So that's absolutely fair. But felonies especially, I'll quiz you. What's the range of punishment for a first-degree felony in Texas?
First degree, 5 years to 99 years or life.
5 to 99 or life. And a huge percentage of punishments on plea offers or on trials go to the judge, sometimes with that amount of discretion. Pleas can be weird. Pleas can be open on, well, let's not bog down. You can decide a huge range of years. We'll get to the case where it was 0 to 45 in a minute. You often are going to be put in position of probation or not. A lot of the pleas, the person pleads guilty or no contest, and then I think we call it plea open or state opposed to the application for probation. Sure. So that's a huge decision made by you. Not only that, you decide the conditions of probation, which might be the most important tool related to what you're just talking about.
Absolutely it is.
So trying to think of something distinctive to ask. I mean, you kind of answered it. But anything you would add that you don't see as frequent as you want, not disparaging your future colleagues, but to put it, speak it into existence. That's right. But, what do you hope to add that you would like to see more of, maybe more specific resources for people who are defendants that are getting punished?
Sure. And yeah, I mean, I guess I can't say I don't know how many judges are actually doing this, but I have seen one judge who has kind of like an additive to their probation. It's not a requirement, but they set up like a check-in with the judge where the person just comes up and talks to the judge one-on-one. Tell me how you're doing, what's working, what's not working, what's going on in your life. Are you having any struggles? For people hearing, this is after they're on probation. This isn't like some expired communication. No. Some stuff like that. No. Correct. Yes. No, nothing improper. Yeah. But the person is on probation and basically having a check-in with the judge, which is not something that happens normally. Now, more judges may be doing this. I'm not sure, but I for sure know of one. And I think it's huge to show that person that someone who is a judge is taking interest in their life and actually cares about them succeeding. Because some people, and not all, in the criminal justice system may not have that support system. Well, let's speak truth to that. I mean, I don't know what the numbers are, and I didn't Google it before we came on, but I would guess a vast majority of people dealing with criminals that have criminal cases pending, that are charged, have roots in poverty, drug addiction, mental health, or cycles of violence. Sure. I want to be clear. None of those things excuse breaking the law, the conduct they're accused of. That's not the purpose of this. And I'm a defense attorney, and I'm mean about it. But what's your role here? If it's prosecuted just to punish, we have the highest recidivism rate in the world. We incarcerate like the third most amount of our citizens. Like, punishing doesn't work. It's not the only mechanism. It's not going to stop behavior. It's not going to keep us safe. What will? I think what you're talking about is what does. Talking to the human being. And there are more resources than people realize out of these criminal courts. And there's some specialty courts, if you could talk to that. Yeah, I was just thinking that myself. So there's, I don't even know if I know how many specialty courts there are. There's Veterans Treatment Court. There's and that's for felony and misdemeanor. Yep. There's a drug court, possibly, I think, for felony and misdemeanor also. I believe so, yeah. There is... I know there's a mental health court for misdemeanors. I don't know if there's one for felony. There is one for felony. Wonderful. I know there's one for women and prostitution. Correct. I'm not sure if it's both felony and misdemeanor, but I know it's available. Yes. And then the Reflejo court is, I think, focused on domestic violence. No, that's it. I mean, is that it? I know those are the ones I know of.
So there's those resources, and
Yes.
I don't want to bore people with the details. We referred to that. Your punishment or probation can be structured a little different. They provide a lot of classes, resources.
A little bit more intense supervision.
Yeah. And again, I'm a defense attorney. I want people to avoid all of it. It's my job. But, the reality is if they're getting convicted, how can we help somebody? Or they're going to face punishment, whether it's adjudication, deferred adjudication, a pretrial diversion. What's really going to help somebody? So there is resources within probation. There are mental health treatments. There are therapies. There are counseling. There are all kinds of drug treatment, outpatient and inpatient. I've seen deferred get inpatient treatment, not a conviction, paid for by the state. You get real inpatient help. Follow up, resources to know where to go to AA or NA meetings.
Right.
Someone just to be accountable to, free drug testing, which sounds terrible unless you've been a drug addict and you realize that accountability is helpful. I have never seen somebody revoked on probation for merely not being able to pay their fines, pay $5 a month, and most of the time you're okay. Don't take that advice all the way, but essentially you're there. There's resources to crazy, and if you have a human being on the bench that's looking at this, there. We'll get to some monsters in a minute, because not all people deserve dignity and to be treated like humans, but some people have done things that just, it is what it is. Time
Absolutely.
To go to jail.
And one thing that I like to point out is that just because maybe someone did something horrible that they absolutely need to go to prison, it doesn't mean I have to be disrespectful as I send them to prison.
Yeah. Criminal clients are often my favorites because they tend to get it sometimes. You know what I mean?
Some do, some don't.
Sometimes like a cost of doing business. We're good.
Yes.
In your work, you've seen victims, defendants, court processes. What do you believe are the biggest misconceptions the public has about how the criminal justice system works?
I think we already talked about it. I think one of the biggest misconceptions is that people aren't pressing charges, that the victims aren't fully in control of the case. Sometimes they are, sometimes they aren't.
Yeah.
And that depends on the prosecutor, who is really the one who is pulling the strings,
I
right?
agree. Yeah.
The prosecutor may do what the victim wants, and so then the victim feels like they're in charge, but really it was the prosecutor's decision. And I think that's probably the biggest misconception. Another one, and maybe I get this more as a defense attorney, is that the judge can't just dismiss their case.
Oh my gosh.
All my clients, they think, well, look, I didn't do this, or this isn't how it went. Just tell the judge, and they'll drop my
just
case.
give them my evidence.
And it doesn't work that way. A judge does not have discretion. Very, very rare circumstances does a judge have discretion to outright dismiss a case.
There's no summary judgment in criminal side.
There's not. And that's civil lingo for people who may not understand what a summary judgment is. Yeah. That's in the civil world. But in the criminal world, a judge doesn't know what happened. They don't read the facts. If the case makes the news, maybe they know a little bit about it, but otherwise they don't know anything other than your name, what you're charged with, your bond conditions. That's about it.
Let's talk about, your role. We just talked at length about people who get put on any kind of probation. That is significant.
Right.
There. The second role is court administration, which is way more critical in how sausage is made than people want to believe. How trial calendars work, how you have your day-to-day, how hearings are set, when you give hearings for suppressions. We talked, I think, off camera about you had a case, or I can't remember if it was on, but couldn't get my witness and they don't show up. The trial's got to move on.
Right.
This isn't TV. We stop for 10 minutes of TV time to go have the cop go get the guy. Correct. Trial's going, the jury's sitting there. Sometimes those decisions are critical.
Judge's discretion.
All discretion.
Mm-hmm. Yeah, that's something a judge can control, whether or not you can take a break and wait for a witness to come or not.
Mm-hmm. And getting appealed on that, it's very much within your discretion. You have a lot of power. Bond conditions are very much within your discretion.
Sure. Yeah. They're first set by a magistrate judge at the jail when you get arrested, but they can be amended by the sitting district judge.
Yeah.
You can, in some circumstances, you can make bond conditions worse. Or you can, if the defense attorney files a motion on your behalf, they can be amended to be more lenient. Mm-hmm. But judges have that discretion there.
It's not near the same intensive as, I was going to say not as intense as civil, but discovery. You make rulings along that.
Yeah.
Yeah, I'm not as intensive, but quite significant.
Correct.
So I didn't want to mislead that. But yeah, I mean, misdemeanors like DWIs, or all DWIs, entitled to like the we call it blood discovery or breath discovery, the machines, the operators, the certifications, all that stuff. Whether the Brady's been turned over, you make discretionary calls on when a continuance is appropriate, if they think something hasn't been turned over or disclosed, when it was disclosed.
Absolutely.
That's all judge.
Absolutely.
Yeah.
Yeah.
So.
Yeah, I mean, the judge has a lot of procedural roles, right? As far as when we go to trial, how many continuances, how many settings. When you want to push something and say, hey, look, you guys need to either say we're going to trial or come to an agreement or make a decision, that is solely on the judge. Some judges push and work harder and go to trial more often than others, and that affects the docket. Docket meaning the number of cases you have in the courtroom, right?
We'll talk about another reason to be so important to have been on both sides, because you've been in the prosecutor's office. Y'all's pace is frenetic. I think you have X number of cases. You probably have at least double-digit cases. You better be prepared to go to trial every Monday or Friday, however you do your trial announcements.
A lot.
Yeah, but defense attorneys have their own little squirreliness about that. Maybe we have other matters going on, or we're set in different courts. If you hadn't been there, you don't know both sides. You don't know what they're dealing with on the, like, I can't do this to this attorney, or you don't know when they're full of it and then they're just trying to get a free continuance when they shouldn't be.
Right.
And
this goes maybe for deciding punishment and talking to a defendant as well. I think the biggest thing a judge needs to do in dealing with everything they're dealing with is be open to listen, but also within reason.
Yes.
Right? You need to make sure that people are telling you the truth, maybe more so when it comes to people who are accused or victims, anybody. You need to make sure, or officers, anyone, you need to make sure they find them credible, that they maybe have proof to back up what they're asking you to rule on. But also same thing with attorneys. Yes, continuances aren't bad, but within reason.
Yeah.
Right? If we're looking at a 15th setting and you're asking for another continuance, that's going to be a different decision than if you're asking for your second continuance.
Yeah.
Right.
And
those are just hypothetical numbers.
Not really. But, for all the talk we talk about prosecutorial discretion, the role of a prosecutor, seek justice, I think protect the public to a degree.
Yeah, absolutely.
Enforce the law. The judge has to run the courtroom. I mean, and again, I don't sound like a defense attorney today. I don't think, just maybe because we're friends or I like you, right? But we get so tied down as defense attorneys, like the judge didn't do this, whatever. Like, think about what they have. I don't know how many cases each judge of the 10 judges have on their plate, but I would assume it's in four figures. Hundreds? Yeah.
No, not thousands. Hundreds.
Okay, yeah. Well, I was including the ones on probation.
Maybe if you go with on probation, it goes higher, yeah.
Yeah, and so they have to manage X number of MTRs, X number of pretrial bond condition motions, X number of cases, however the court does it in pretrial or versus trial settings.
We do have that special, the district court judges are not getting cases pretrial now.
Oh, okay.
Very, very rarely.
Yeah.
Because we have pretrial courts.
Good.
There's 2 now.
Yeah. I remember the MAG court used to hear like my motions. It got kind of squirrely sometimes.
Right.
Yes,
well, now there's something called a pre-indictment court. And
good.
Miguel Nahara is the first judge, and he's been there for at least 2 years.
How does that work with the DA handling your case, like for pleas and stuff, though?
They have prosecutors in that court.
Okay.
Yeah, and I don't think they do pleas that often on pre-indictment cases, but it's solely for felony pre-indictment cases.
Yeah.
And then Judge Woody Halstead just got hired as the second one.
Okay.
So they just started having a second one within the last month or so.
Yeah.
So there's not a whole lot of room for those courts, but they are important. I think that they hear all pre-indicted, like bond motions. I think that's significantly what they hear is bond motions.
Yeah.
Motions for examining trial, things like that. They hear those.
When we're talking about bond motions, people, you get arrested, and you're almost always entitled to bond. It gets a little squirrely, but let's assume always entitled to bond. And they actually just had a proposition pass on changing some of that.
Oh, did it pass? I didn't know.
It did pass, like 6130. It felt cosmetic. You don't have to comment if you don't want. It felt cosmetic because it just simply was like it still has to pass a test before you deny it. So it's like I I don't like it. I'm a defense attorney. Like, to me, y'all had enough discretion to keep people off the street that were bad or whatever. But anyway, you're entitled to bond, but the court, one sets the number, which is a little misleading because we get what's called surety bonds. So you only got to put up 10% or 5% or 3%, whatever the bond company does. But more important, conditions. Are you at, we call it house arrest with an ankle monitor? Are you on tracking only? You got an ankle monitor, but you can go certain places. Are you almost on your own recognizance? Put the money up, you show up to court, you're fine. Who can you talk to and who you can't? If you got a kid victim, a lot of times you can't speak to that victim until the trial's over. And that gets squirrely when we get to this is your own kid. So there.
Absolutely.
Yeah. That actually leads to the next question. And we'll fly through these questions and take a break. And I know you want to get out and do your campaigning. I like to hear that you've done family law. The question was, family and criminal law intersect, domestic violence, protective orders, child custody. How do you approach hybrid cases with both criminal and family implications? I'll frame the question because as a role as a criminal judge, I'm glad to hear you have some family experience. And how do you take that into effect? I know you're saying you probably not do as many bond conditions because it has the court, but you still have to deal with that issue.
Sure.
You've got a parent accused of beating their own child, and maybe they're not being terminated. So maybe expand on that a little in your role in that case.
So all I can really say, I think, is that all of that has to be taken into consideration.
Yeah.
If there's a civil case, sometimes I think that the civil cases may go to motive for victims to say things in criminal court, or motive for how defendants act. As far as because there's a civil case going on, the criminal case takes precedent over the civil case, but that doesn't necessarily mean that they won't intertwine. Sometimes a civil case will have a no contact order with a victim, but the civil judge has ruled that there's they get some custody, right?
Yeah.
Well, they can't have that civil custody if that no contact order is in place.
Right.
So that's something that, as a criminal judge, that I would want to know. I want to take into consideration what this other judge ruled, or why that judge gave this person who's accused some custody rights. And if that's something I think, okay, now I think maybe they can have contact, but we have the alternative of no contact going to the no harmful or injurious contact.
I have a case right now where it was my guy had, it's pending, but has custody. It was 50-50 between the kids, but the oldest kid he had most care of, and the kid's trouble, poor guy, drug addict and stuff. But alleged that dad hurt him. It was kind of the allegations of self-defense, struggle, whatever. Year and a half old, and we had already dealt with it on the civil side. It was, police report was filed. For whatever reason, state finally picks it up, and they put it into a contact order. We're like, we got custody, man, like there.
Right.
And so what did I have to do? I had to give the amicus and the order to the judge, and it wasn't hard. The DA didn't fight me on it, but yeah, that does create some tension. Like, Judge, I appreciate what you think you see, but this issue was litigated in the civil side. I haven't had an experience where I have rulings from the civil side where I present to the magistrate judge, the pretrial judge, or the court of the case, say, respectfully, I need the bond to change. Like, my guy has custody.
Sure.
Whatever you're going to do. I haven't had an experience where that doesn't get changed. I'm sure there's circumstances that's appropriate, but I haven't had that happen. But
Right.
Yeah.
I would say it's probably more rare, because if somebody actually believes that they should have custody, well, then maybe it wasn't as bad. If it was really bad on the criminal side, I highly doubt that they're going to actually give someone custody on the civil side, right?
This is a weird case.
Right. But the civil side does, unfortunately, tend to move faster. That's another misconception that we didn't talk about, is how fast the criminal justice does not work, because it's not fast. It's very slow.
It's
too slow.
It is. I don't know if this is a misconception, but I do want to ask the question while I have someone with your experience and expertise here. I understand the importance of the criminal justice system to protect the public, to enforce the law. I mean, you have to have it. It doesn't work otherwise. We can't just trust each other to play nice.
Right.
What role do you see it as far as closure or recompense for victims? There are cases where you can get restitution financially. That is critical, I would imagine, because it's hard to enforce judgments on the civil side and all that stuff. But to me, it's a tough role. I don't want to be in your position, prosecutor or judge, for the reason of it's not really your job to make the victim feel better. And I don't mean that in any way harsh.
Right.
It's broader than that.
It is.
But I think there's some misconception about we're here to seek vengeance, or justice means vengeance.
Right.
Justice, it's not really what it means, right?
No.
Yeah.
No, I mean, justice, like I said before, justice means doing what's right.
Yeah.
And now in my career, I have had several times where I have to have that hard conversation with a victim to tell them we're not going to be able to get the justice that they feel is appropriate.
Yeah.
Because legally we can't prove the case, or maybe they want harsher punishment than is appropriate.
Yeah.
Or vice versa. I've also been able to give victims the justice they feel they deserve, or they feel is appropriate. And I do think that after a trial, win, lose, or draw, I do think that victims do feel just standing up and speaking for themselves on what happened not being right. Like, I think that gives them some closure.
You're talking about victim impact statements?
No, in general, just
Okay.
testifying.
Yeah.
I've found, maybe my experience, I'm thinking more of like a child victim, but even just getting up on that stand is extremely hard, especially for a child. And
Yeah.
to be able to stand up and say, it's not right what you did to me,
Mhm.
that has therapeutic value for sure. So I mean, it's there, and that's not a reason to go to trial. Obviously,
Yeah.
you go to trial because you believe in a case, you believe someone did something wrong, and that they should be prosecuted for it. That's why you go to trial. But
Sure.
that does happen, right? Sometimes whether you win or lose the trial, you do get that. Going back to victim impact statements, that is a right that victims have in Texas, that after a plea or after a trial, they are allowed to give what we call a victim impact statement to the defendant or the court. And the defendant, and actually the court, is not really allowed to say anything back.
Yeah.
It is purely a allocution statement on the victim's part, and it is meant to be therapeutic.
Yeah.
They can say whatever they want. I would always tell my victims within reason.
Yeah.
We're not committing any crimes. We're not making any threats. We're not, we're
Probably
not
not cursing.
saying anything.
Yeah.
Yes, absolutely. Shouldn't be cursing,
Yeah.
but it is meant for them to tell the person who wronged them, how
Yeah.
they feel. And surprisingly, it doesn't always go how you think it would go. It isn't always, you're horrible. A lot of times it's, I forgive you.
Yeah.
And just sometimes giving that forgiveness is healing for the person as well. So it is meaningful.
Okay. We've answered this, but we're going to go through because Ashley would kill me otherwise. From your experience, what traits make an effective judge when it comes to fairness, community trust, and integrity?
Yeah, absolutely. I mean, like you said, we have gone over it. I do think the willingness to listen and to learn and to ask questions on an individual basis and treat people with respect, but within reason. Also, like I said, right, you need to be cautious and not taken advantage of as well. But also make sure that we are holding people accountable. Again, I go back to the role of a parent, which is kind of ironic because I don't have kids. But as a parent, you don't want to tell your child, well, if you do this thing wrong, this is going to be your consequences, and then not follow through.
Yeah.
So I've seen that. I've seen judges who threaten consequences and don't follow through, and I don't think that's effective because then they learn that they can get away with it.
Yep.
Right? So you have to stand your ground. You have to be tough. You have to make hard decisions. But you have to remember that these are human beings that we're dealing with.
I agree. What advice would you give younger attorneys who want to make a difference in public service or eventually run for judge?
Yeah, I mean, I think stay true to yourself. Remember self-care. And remember that these are human beings, regardless of what side of the courtroom or where you are in the criminal justice system, whatever your role, whether you're a probation officer, an officer, a bailiff, a court coordinator, court reporter. I mean, court reporters don't deal with people as much, but
Sure.
the judges, prosecutor, defense attorney, that you need to remember that this is someone's life you're dealing with. This is probably bigger than just your day-to-day, okay, I saw 20 defendants today,
Yeah.
right? I mean, you can't get lost in the criminal justice system. You have to remember that this is a big deal.
Yeah. A felony conviction, a weekend in jail, a month in jail, a year in jail.
Yeah.
Again, it's often appropriate.
Right, absolutely. But imagine yourself spending
Yeah.
10 hours in jail,
Mhm.
I mean, 12 hours, which is what a normal, even if you can make bond right away in jail, you're probably spending 24 hours in our jail in Bear County.
And we're relatively efficient getting people out. Some of these smaller counties, it's a weekend.
Right.
It's rough. Finally, and then we'll take a little break. If you're elected, what legacy do you hope to leave on the 226 judicial district courts? and the San Antonio legal community?
Well, I just hope that I'm seen as a judge who treated people fairly and made a difference. I want to be a judge who definitely, I think I've said this over and over already, but I want to be the judge who treats people with respect and will listen, but also is tough. And I also want to be involved and stay involved in the community.
Yeah. So that'll be legal heavyweights, but it's a great place to end for the second, because I want to talk about a case that you worked on to show, because I think you're showing a humanity that I want to see on the bench, that we often do. I'm not trying to say every judge is rough. No. We often do. Yes. But I do want to show a side of you that goes after the monsters that we need to go after. Yeah. And so we'll get there. So, all right, we're back. So that was Legal Heavyweights. Thank you so much for being on.
Yeah, it's been fun.
I'm excited for you. That campaigning, I know it's exhausting.
It's a lot of work. It's a second job, but we're here for it.
I teased you about whether you're working out. You said your shoulder hurt. And like, when do I have time?
I know. I don't have any free time right now. Yeah. We are working full time and campaigning anytime we can, and also trying to remember self-care when I can. And I know working out is self-care, but
I'll get you there. We'll finish it
rest.
With that.
Rest is my priority self-care right now.
That's fair. We ended the first segment with, or the whole segment. And one of the reasons I want to have you on, one of the reasons I'm excited for you to run for judge, is, again, bringing that humanity and that dignity to the defendants. And I'm not saying it's going to change with the next case, but in my experience, most people think of criminal defense or criminal prosecution cases, and what do they think of? They think of the serial killers. They think of the horrible cases. They think of there. And honestly, I would argue a significant portion are, again, people who did bad things, even really bad things, but they are people that are struggling in life and stuff like that. There are some monsters out there. They're still humans. Treat them as such. You still treat them with dignity. But there's a case we brought up today that you prosecuted. The case is Jose Angel Ruiz for State of Texas versus Jose Angel Ruiz. It's reversed because we have the appellate attempt.
Oh, yes.
But this is a case of, I'm going to say child abuse, but child torture.
It was torture.
So give us what brought the case on? What's the allegation against this gentleman?
Well, it wasn't just Jose. Right. The mother of the child also was charged. Her name was Katrina. Oh my gosh, I just blanked at her last name. Katrina.
I'll be fine here.
The victim is Mercedes Lozoya, but Katrina's last name was not Lozoya.
Mendoza.
Thank you.
There you go. Yep.
So yes, Katrina Mendoza is the mother of the child. Mercedes Lozoya, she was 5 years old when she died. She died on February 7th of 2022. Thank you. Mm-hmm. I was debating between a 22 and 23.
I'm cheating because I have the background from the case in front of me. Yep.
And the reason I remember February 7th so much, she died on my birthday. So that is another thing that makes this case kind of stick with me.
Yeah.
But I was the intake prosecutor when the case came in. And
what does that mean?
So that means I'm reviewing the case that is brought over by the police department. Anything they have, which one thing that people may not know is it doesn't come in all at once. It's not, here's every evidence, everything you're ever going to get on a case. It kind of trickles in. It starts with maybe a warrant, maybe only a warrant. Starts with maybe a warrant or a police report and some pictures, maybe some body camera. But it also kind of trickles in throughout the filing period, which I guess I'll say if someone is in custody, the DA's office has 90 days to file a case before they are potentially eligible to get a PR bond. It does not mean the case goes away, but that means they're eligible to ask the judge to be released from jail without paying any money. Mm-hmm. On a case that is severely violent, that is a big deal. And as a DA, you do not want to hit that deadline. Right. Because that will absolutely, first of all, it will absolutely hit the news, right? Which is probably appropriate because that's something that should not happen. Right?
Well, but also, I want to freeze to say, it's easy for people like me to throw rocks and be like, oh, well, worried about deadlines, worried about news stories. But that's a real factor in your life, your job, the elected DA who's running things, and people make voting decisions based on the news they read. So it's inappropriate and just unrealistic to say news stories can't have some role in your thinking. Sure, naively, sure, it has no role. I don't care what the news. No, that's not how the world works. Right. And And if we don't want it to be, then let's stop buying the news stories if that's what we're going to say. So I think that's unfair for people to.
Well, I think it holds
criticize.
people accountable also.
Absolutely,
to a degree.
too. Yeah, there's a very positive element of that.
Sure. So within that 90 days, though, especially if somebody stays in custody, if someone bonds out, that deadline kind of goes away for the most part. There is still a deadline, but it doesn't get enforced as much because it's not beneficial to the defendant.
Right.
Right. So the in custody deadline is the one people mostly worry about.
Yeah. Because then it's you can like do the motion for examining trial and some other stuff before indictment, but we can avoid all that.
Right, it gets hairy. We'd be talking for another 20 minutes just about that.
Yeah.
But so the evidence comes in a slow process. So your job as the prosecutor, first of all, it takes, I would say, at least a month to hit the prosecutor's desk, if not longer, after arrest, because there's a whole process it has to go through. It has to go to an investigator. It has to go to a paralegal. It has to go to a victim impact. Or a victim liaison, crime victim liaison, yes. Mm-hmm. And people who reach out to the victim or the next of kin or whatever. So there's a whole process. Before
and this is when someone's arrested, right?
Correct.
Okay.
Before it gets to, well, the same process goes if someone's not arrested, and then that's what we call an at-large case, where they won't get arrested unless the case gets filed.
Yeah.
But on arrest, it still takes at least a month, if not longer, to hit the prosecutor's desk. So that's a third of your deadline also. Right. So then you get this file and you have to review the police reports, review anything and everything you can in order to see if it fits the legality of the crime, see if you can actually prove the case beyond a reasonable doubt, decide how to charge that case, reach out to the next of kin. You want to have a conversation with them, and then you have to present the case to a grand jury, which is 12 people of the community who make that decision. Just, is there enough evidence to go forward and prosecute a crime? That's literally all they're deciding. They're not deciding guilt or innocence.
Have you ever had a case the grand jury didn't indict?
Yes.
What?
Several times.
Come
I know.
on.
No. Swear.
No way.
Swear.
That again, I'll just blow smoke. That has to speak to your ethics, because there's no way to convince people with no opposition. I have to believe that. Yeah.
Maybe. So I also will say that, I mean, the grand jury process is secretive, right? So I can't say, hey, when I took this case to grand jury, this is what we talked about. I'm legally not allowed.
It's also not adversarial.
Right. It is not. It is one-sided. The prosecutor only goes and tells the grand jury what their evidence is. Are there times when I expected a case to get what we call no billed?
No billed, yeah.
Right? Yes. Are there times where a case got no billed that I was not expecting it to get no billed? Yes.
Really?
It happens. It may be more rare.
Does jeopardy attach there?
No.
It doesn't, right? So you can.
No. However, the rules are you have to have new evidence come in.
Right. Okay.
So without something changing, without something new, you can't just go.
Try again.
Correct. You can't seek or shop for a better grand jury, right? You have to have new evidence.
But this is why it's important to get that. You got a month already gone from your deadline. You get the file. I better get it right, because if I mess that up, I'm lazy. I don't want to bring this piece of evidence in, or I don't want to wait on this examiner's report, or I don't want to wait on this toxicology, whatever it is. Yeah.
Right. But it also, and maybe like you're saying, I'll take credit here. It might go somewhat to my ethics, because I always thought that it was very important for me to tell the grand jury the good, the bad, and the ugly of every case, because I'm not going to, even though maybe it is my control to not tell that grand jury everything, I don't have to. No one's there to maybe judge me or criticize what I'm telling them and what I'm not telling them. But how is it going to be beneficial to me to not tell them this bad thing about a case when I'm going to have to prove that to an actual jury later?
I appreciate that statement. I believe and trust you, which is why I'm happy to have you here. Even if I had a massive audience, maybe I will one day. But I don't, maybe this is cynicism, I don't trust that's the normal or common approach.
I don't know.
I would love to believe it.
Everyone. I would agree with that.
Fair.
I would agree with that.
And again, back to the prosecutorial discretion, that's a big step.
Sure.
It's one thing, I can't think it was the, and you don't have to leave it alone if you want to comment, but the Ferguson case, Ferguson, Missouri, the I think Michael Brown was his name, I can't remember, but it got no billed. But it almost looked like the prosecutor was trying to get it no billed because we don't want any part of this. I don't know. That might be true, might not be not. But I know that there are times where it's like we can almost blame the grand jury. Hey, we tried, And so there's a massive opportunity for manipulation that way, but also on the side of like, like I don't have to give the ugly. I've got enough if I just leave this out to indict, and maybe the defense attorney won't catch it, or juries like me and I'll win. That's easy to do. So it is. The fact that my comment took you off guard to say it's ethics tells me it is. Your ethics that do that, but that's a big deal.
I think somewhat is what I do think somewhat, right? Yeah. But I mean, your case isn't going to get better if you if you don't tell the grand jury everything. Your case isn't going to get better. It's only going to get worse.
You are right. I just mean it's not my experience. Let's leave it there.
Right,
yes,
right.
Yes. Sorry. Okay. So in this case, the intake.
Yeah. So I did work on this case from the beginning. I ended up having a lot of conversations with the lead detective on the case. I also had conversations with the medical examiner.
Well, let's look at, so the victim.
Yeah, we didn't get there.
Yeah, so she February 7th, she passes away. Correct. In an ER, I think.
Yes, she arrived already.
She arrived. Correct. Yeah, I think they pronounced her 14 minutes later, but right. she's dead when
dead on arrival. Mm-hmm.
And she's beaten. She is
beyond severely.
Yeah, this is a 5-year-old little girl.
5-year-old. She was tortured for about 2 weeks.
Hair is missing.
Almost entirely.
Teeth are missing.
Some of them, correct.
Described as ashen gray from two things. One, just the bruising all over her body, but also the bruising was so severe that there was muscle death that led to rhabdo, whatever the word is for that. Rhabdomyolysis.
Rhabdomyolysis. Yes, that was a word I had to learn as well.
Which is actually what killed this poor girl.
Correct. Which is caused from repeated blunt force trauma,
right.
Repeated hitting of the child, repeated overworking of the muscles from being hit. Yeah.
The place you probably hear it, like marathon runners or CrossFitters that struggle to keep their calorie intake or their muscles start to eat themselves. But
yes, basically, if rhabdo is not caught, which in people where they're working out and they get rhabdo, you can catch it because you start feeling ill and you go to the doctor, right? And it can be caught. And so it's not always deadly, but if it is untreated, it causes, I'm going to mess this up. It's either kidney or liver failure.
I think it's both. I think it was kidney failure more acutely. So this girl is one of 2 children for this mom, this Miss Mendoza, who has a boyfriend, Jose Ruiz.
Correct.
So she presents, is dead. They see the bruises, they see the things, the torture, the hair. Call the police, investigated. I think immediately probably sent to a coroner's office to be examined. And at some point you get that information.
Correct.
Okay.
Correct. And then I'm like I said, I'm talking to all the people involved as much as possible. Many people may know or may not know. We have Center for Miracles here, which actually I think just changed the name, but and we've got multiple physicians who are specifically child abuse physicians. Their focus and their career is child abuse. And so usually on these cases they're involved, and there was one involved. So I had talks with her, try to just learn as much as I can about the case before making that filing decision. And we also, on a case this big, we talk with, our bosses, like you said earlier, right?
Sure, yeah.
I have people ahead of me or above me, I guess is what I want to say. That we have decisions and we talk it out and decide, what we're actually going to do going forward.
And in this case, I believe, I would assume, I don't know if it's in here, the Department of Family Protective Services is called.
Absolutely.
Because it's child abuse.
Yes.
I would hope that other young girl, this is a 5-year-old girl, she's a 6-year-old sister, was removed probably immediately.
Yes, absolutely.
And so they start a civil case to remove the child.
Correct.
The only reason I bring that up is important is now there's an investigation over there as well.
Correct.
And that's ongoing.
Correct.
And so you have an interview done with that child. I don't think, not even your office, but not your criminal division of the office,
Correct.
The department. And so all this hits your desk. And what do we charge both parents? One parent and one boyfriend.
Right. So they both were charged with what we call injury to a child by omission and then also by commission. So injury to a child, serious bodily injury or death by commission and omission. Commission means actually causing the injury. Omission means not seeking medical care or not acting quick enough to where that caused the injury.
Yeah.
They both were charged with that, which is a first-degree felony. I'm going to throw it out before you ask me why not murder. Murder has a different intent element to prove, and it's the same level offense of injury to a child.
It is, but you shared with me, and again, what are you going to cut? You can. But it could have been capital murder because the kid's under 10.
It
Is it 10 and under or under 10?
Correct.
Yeah.
It could have been capital murder. And that was a decision for the administration at the time at the DA's office that they did not believe that that was appropriate. So
yeah, but to be clear, you charged them with the injury to a child, SBI, serious bodily injury, or death.
correct.
Because obviously I say obvious. I mean, you got to prove this, but
Correct.
as alleged, the injuries caused this kid's death.
Correct.
So, which yields a 5 to 99 or life punishment range.
Right. The same punishment range as murder.
Right.
So same consequences, just a different title, right? It just maybe doesn't sound as bad as murder, right? But yes, it did cause her death.
I mean, when you say injury to a child causing death, it sounds like murder anyway.
Right.
I mean, so
Right.
yeah. So you kind of did. I mean, I don't care.
Right.
It's not the murder statute, but
Right.
yeah.
Exactly.
Okay.
Exactly.
So-
It's just in that you have to prove the intent to cause the injury, not to cause the death,
Yeah.
basically.
And I mean,
It's the
that's
difference.
that's fair to make that discretionary call, I would say.
Yeah.
I don't think that,
Right.
You know, so especially if we get the same punishment range,
Right.
are we just making a political point to use the capital punishment or something like so?
No,
all
right.
those things have to go into account. So
Absolutely.
I think any criticism of that would be, I would struggle with criticism of that decision.
Sure. Well,
So,
I mean, and this also goes to show the control and the discretion prosecutors have.
Yeah.
Right. You have the discretion of whether to charge someone with a capital murder or a first degree felony or a third degree felony. Right.
Yeah.
So and we did charge other offenses on both defendants. I think they both were charged with an aggravated assault with a deadly weapon. They were also both charged with injury to a child, a third degree injury to a child, multiple counts.
Yeah. All right. So do you know how long after her death they got arrested?
The Jose got arrested the night of, but
He
for
brought her in,
something
right?
else. He brought her in with Katrina.
Yeah.
And Jose got arrested, but he got arrested for violating a bond condition because he was caught with a firearm.
Okay. He had a prior. He had
Another
pending-
case pending, and he got caught with a firearm. So he was arrested for that.
Okay.
And then it was a week or so, maybe, where they both were officially charged with the injury to a child.
Okay. So is that a police department decision at that point when
Yes.
they're arrested? Okay. So this hasn't hit your desk yet, but
No.
they have that. I say discretion. That's their role. They make the arrest before they present it to you. What charges?
Correct.
We are alleging this.
Correct.
We put you in. You get
Yeah.
magged, as we call it.
Sometimes on these big cases, there is prior communication.
I had a friend. I mean, to give some credit, again, I will bash the DA's office through other content coming forward. But I had a friend of mine who there was an issue of whether a child was left alone for a certain amount of time. It was a younger child, and the child screwed up, left themselves outside, and the neighbors called, and it was just a mistake. The child had a phone there. There was an emergency for the parent. They came home, and the cops were talking, and they had already called and said, "Is this an offense or not?" And it turned out not to be. You know, and it was just a miscommunication about where the kid was. My point is that communication was happening even in a lower level offense. Like communication happens
Yeah.
frequently, right?
Yes.
Yeah.
Ideally, I mean, communication is key.
Yeah.
The more communication the DA can have with police agencies, the better.
Yeah. So, okay, so we're in, and they're charged with what you just said.
Right.
Kind of go, what's the next step? I mean, it gets assigned to the court. You're the intake DA. How did you become the prosecuting DA?
Well, I asked to stay on it for
Okay.
one. I mean, this was a very severe case. It was difficult for me to view this evidence.
Yeah.
It was horrible to see.
I've skipped over it a little, not on purpose, but the girl, I mean, I read it, and you've described it to me.
Yeah, I kind of
Beaten.
sometimes leave out the details
Yeah.
because it's hard. It's hard
It
for
is,
people to hear.
and I don't want to, like, glorify the violence.
No.
But to how do I say it? To make the point of what the actions actually were. They're two little kids, two little girls. One's not touched,
Not at all.
and this other 5-year who shouldn't be, you know,
Right.
I'm not wishing that.
Right.
But this other 5-year-old girl, a year younger, is beaten to a point she dies of
Correct.
rhabdo. And I say that to say it wasn't like an acute bleed. This is just consistent beating.
Correct.
I believe
No serious bodily injury, which is very crazy to say, honestly.
Right.
Because it was just that significant number of, I hate to say regular injuries,
Yeah.
but serious bodily injury under the law is protracted loss or use of, your bodily function, right? Like if you can't use your arm for a period of time, or or you have to get reconstructive surgery, or something significant like a fractured skull, cracked skull causing a brain bleed, that would be serious bodily injury, right?
And there's a whole lot of case law, like what is and isn't, right?
Absolutely.
Is that a jury question?
No.
It's a legal question?
I guess it could be a jury question based on whether they find guilty of something with serious bodily injury, or maybe they find guilty of a lesser included. But it's not they don't have to find it true that there was serious bodily injury. It's either guilty or not guilty.
So if they go, it's not aggravated assault or enhanced serious bodily injury.
Right.
It's yes or no to that question.
Right. I mean, it's either guilty or not guilty.
Okay.
Right.
Right. Yeah. So it's an element at that point.
It's an element.
Okay.
Absolutely.
I don't know why.
That we have to prove beyond a reasonable doubt.
I'm a dork. I do this for a living, so
That's
I don't know
okay.
why. Okay. The girl was locked in a closet, standing on tacks.
Correct.
Like
thumbtacks in her feet. Mm-hmm.
She was tied nearly naked up
to a pole.
That kind of position.
Mm-hmm.
Her hair was pulled out.
Hair was pulled out.
She was ashen gray from her condition anyway, right?
Right.
We find out later in the investigation, through interviews and investigation through the other child, was forced to lick her own urine if she had a bathroom accident. I believe there was testimony of feces being pushed in her face from like the dog. Mm-hmm. And again, the physical horrid treatment, imagine the psychological things they were doing to this girl. Mom's doing it or watching it happen or both. I mean,
both.
Yeah.
Yeah. If you believe her testimony fully, to the extent she put a lot of the blame on Jose, which could be true, but I don't think she was innocent in this.
How long did she know Jose? It was a couple of weeks, right? Like it wasn't.
No, she knew Jose. They were dating a little bit longer, but
okay.
Jose had the possession of the child for 2 weeks.
So mom relinquished
About
possession to him. I can't handle this.
Correct. But then she moved in with him shortly after, within a couple days after.
Yeah.
Mm-hmm.
Okay.
So she was present for a lot of it.
You charged them both.
Correct.
And then did they get court appointed? And if you can't say this, tell me. They get court appointed counsel, right?
Court appointed counsel.
Yeah.
Mm-hmm.
It's a big deal because these cases are hard. Just the mental exercise, the capabilities to try a first degree felony requires a level of expertise, a level of capability,
right.
to get on what we call the wheel or to be permitted to be appointed to first degrees. I don't even do first degrees. I do second and down. I don't take appointments anymore. I would qualify now, but I wouldn't even apply for it. That's another conversation.
Right. You have to qualify. You have to have
right.
the experience to get on that wheel to get court appointments.
Yeah.
And I will say another common misconception is that court appointed attorneys or public defenders are bad, and that is not always the case.
It's not always the case. It's hard.
We have some very qualified attorneys who are on our court appointed wheel,
yes.
and it is a choice. It is a choice of the attorneys.
It's hard because I want to clear. I have no dispute. We have wonderful advocates that take court appointments
Correct.
all the time.
I mean, there's good and bad.
Yes. It's just, in my opinion, and this is taken for what it's worth, they aren't compensated to a level I think they can do the job they could be able to do. I think if that compensation were doubled, and I mean doubled, it would create opportunities for more advocates and a better system. That is pure opinion, and I don't know what else to say to that. Yeah. But I do think they're not, the level of compensation sometimes leads to an unfortunate lack of aggressive representation. In some cases. In some cases.
I do currently take court appointments myself, and I strive to try to treat my court-appointed clients the same as I would if they were hired.
I did it when I did them. I just got away from it when I realized I just could not advocate at that, and make ends meet.
Sure.
But anyway, to get there. So they get court-appointed counsel, these
Correct.
horrible first-degree crimes. Did either one of them make bond?
No.
Okay, so thank goodness. Yeah. Again, I'm a defense attorney, but this is bad.
Yeah.
Okay.
Neither one of them made bond. They both stayed in custody.
Right.
And it was, let's see, we tried the case in March of 2024.
Okay. Most
right?
90-something% of cases plea.
Correct.
Why couldn't this one? I mean, I think to the
the
degree
offers,
you're allowed to share.
Yeah, the offers were high.
Yeah.
And as a defense attorney, I do kind of see why they didn't accept the plea, because
Well, why not, right?
they're high, so
Yeah.
why not roll the dice, right?
Yeah.
The Katrina did accept a plea. Katrina accepted a plea of what we call a cap of 45 years, meaning the judge could have sentenced her anywhere between 5 and 45 years.
Or probation,
I think
right?
we opposed probation. We did let her apply.
That's what I read.
Honestly, I think we were pretty confident she was never going to get probation.
It was Judge Stephanie Boyd, right?
Yes, it was Judge Stephanie Boyd.
Yeah.
And I don't think she would have gotten probation from anyone in Bexar County, not with these facts.
No.
The reason she got the plea offer she did was because she testified against Jose.
Well, let's skip to the end of that. She got 45 years.
She got 45 years.
Yeah, so I don't think that was a plea that hurt your office image at all.
No.
Nor should it.
Without saying what the original plea offer was, we didn't give up much.
To Jose?
No, to Katrina. We didn't give up.
Oh.
We didn't go much lower on the original plea offer for in exchange for her testimony.
Okay, well, I mean, it's 5 to 99, but or life. What does that practically mean, and for how much jail time you serve?
Right. So on a case like this, you are serving half before you're eligible for parole, or 30 years, whatever is greater.
Whatever's greater.
I mean,
shorter.
Whatever is shorter. Sorry.
Yeah,
Yes.
yeah.
So 30 is the most you're gonna be eligible for parole at 30 years, no matter what.
Yeah. But then you have to go to a parole board. It's not like you're getting out.
Yeah. Right. It's just a possibility, right?
Yeah.
So that means anything from 60 and above, you're eligible for parole at 30.
Okay.
And so will you get that? Maybe, maybe not, right? It depends on the parole board. It depends on what offense you committed. It depends on probably prison population at that point, right? Your behavior.
But they also take into account the offense and the facts around the offense.
Absolutely. And people can be heard at parole board hearings. Anyone can be heard on whether or not someone should be granted parole.
Yeah, and look, I have no love for this gentleman we're going to talk about in a minute to state the obvious, but there are people who rehab in prison, turn their lives around, turn into advocates of change, of maybe rehabilitation or whatever. Maybe there are even horrific crimes, rationales to parole them later, but there is a board that makes that decision, and they're not guaranteed. So I like the idea of reassuring people, like a life sentence is a life sentence. So, it's pretty rough, and as it should be.
I mean, I'm sure that a life sentence is less likely to get parole at 30 years than, say, a 60-year sentence. I would think that they're going to consider that, hey, wait, this wasn't 60 years, this was life.
Yeah.
But I'm not on the parole board, so I don't know the practicality of that.
Right, and they have other considerations that we don't know.
Absolutely.
All right, so we go to trial. How long was the trial?
I think it was about a week and a half.
Yeah. And what was the defense?
Well, so remember, we only are trying Jose.
Right.
Katrina testified against Jose. Defense was basically Katrina did this, and Jose did not. It was all Katrina.
Yeah, and you didn't report it. I mean, I don't want to mock the defense because, like, what defense do you have? I was trying to think, like, what could I even?
Well, there was a significant amount of evidence in this case.
Yeah.
Jose's cell phone was huge in our prosecution case. Huge. The things that he took pictures of and the things he had on his phone, horrendous. I mean, again, this is the worst case I've ever prosecuted.
He's relishing in it.
Yes, absolutely. You take pictures of something for what reason? Why? Just in general, as a human being.
To memorialize,
To remember or to share.
Yeah.
Those are the two reasons you take pictures of something, right? Mm-hmm. And either one of those reasons of why he had pictures of the torture this little girl is going through is horrific.
Yeah.
There's no reason why he should have had a picture of this on his phone. But he was keeping pictures and things on his phone.
All right, so in the story, he gets life.
He does.
And she got 45 years.
Correct.
They're not old, but they're like 30-ish?
A little bit younger, I believe.
Yeah, so I mean, it maybe in another century we're talking about, not century, 30 years, maybe there's a conversation about their parole, but I mean, I think we can say they got justice.
22 and a half before parole.
Right.
And then he's looking at 30 before eligible.
Yeah.
Right.
And again, people commit crimes in prison too. They tack that on, so it happens.
Correct.
So you're, trying to fit this with the themes we have. Your colleagues with the two defense attorneys, we don't have to name them. But, you still have to be civil with the other side.
Technically three defense attorneys. Sorry,
really?
The third one got added. Yeah.
As an appointed attorney?
Yes.
I'm a dork. That's interesting to me. I didn't know you could do that.
Yeah.
So, yeah.
Well, it's up to the judge.
Fair. I guess they have a lot of discretion there. You know,
And this was a very big case. I mean, this was equivalent to a capital murder.
right.
It just wasn't procedurally tried like a capital murder because trying a capital murder, well, maybe it was procedurally tried like a capital non-death, but a capital death case is definitely different, right? But the amount of evidence and, I mean, the facts, everything, it was very similar to a capital.
How do you have the confidence as a prosecutor? I mean, juries do weird things. It's easy to say I've got the slam dunk, and I do this on the civil side a lot.
Never have a slam dunk.
Yeah, I tell my
Never have a
clients it's
slam dunk.
80-20 at best no matter what. That's the best I give them. And
Never.
yeah,
I don't ever make promises. I never made promises to victims, never make promises to my defendant clients.
yeah,
Because you never know what a jury's going to do.
yeah.
However, this was so horrific. I felt pretty confident in
Fair.
my case.
Yeah.
But you also never know. You never know what a jury's going to get hung up on. Talking to juries after jury trials, they think of things that you never thought of.
It's wild.
Never thought of. And then they'll say things that have nothing to do with the case. Like it's very interesting.
I had a family case where mom had moved to Kansas, violating a geographic restriction. And so before I got on the case, the judge had kind of punished her and said, kids are going to stay with dad in San Antonio. You moved to Kansas. And then we had a jury trial on the GO and who's primary. The kids in dad's care had missed like 50 days of school, were flunking classes, begging to go home to mom. There was no abuse, but they like eating ramen every day. Dad wasn't a bad guy. He was not an adult.
Right.
And I just eviscerated him on the stand. It was just, you know, we got this. The only question I had is whether they would let her be in Kansas or you're still primary down here. That was the only question we had in my mind. Mom had done one stupid thing. She had put on an Instagram post etching in the home in Kansas, and the initials of the kids had the last name of stepdad and not dad, which is bad.
Yeah.
And she lost custody over that. These kids hadn't been to school. These kids were not eating. These kids, and it gave him custody.
Wow.
And you're just like, I'm just like, I don't, you know, what did I have to show you, man?
Yeah.
I mean, I wasn't rude to the jurors. I don't do that. But I was just like, I don't know what you want me to say. Like, I assume that was it. Yeah. It's like, well, maybe they won't see him. I'm like, I just told you the judge is going to put a possession schedule in place. And you're just like,
right.
I give up. And I won't lie. I was pretty shell-shocked that day.
Yeah. No,
Yeah.
as a prosecutor, I got a not guilty. I lost a trial and then went back to talk to the jury. And the first thing they told me was, oh, he did it. Literally, the first thing out of their mouth was he did it. And I'm like, what?
And
They got hung up on the legal definitions of intentionally, knowingly, and recklessly and said it didn't meet those definitions. So you never, ever know what a jury will do.
you know what I should have done? The conversation went here is read a jury charge. It's worth doing. They're this thick.
It would take you forever.
It would take you forever.
You would put your audience to sleep.
You do. And I mean, I'm licking my chops as a defense attorney because there's my chance in some of these cases, right? Mm-hmm. Oh man, I always feel like I'm up against it if I'm being honest with the defense side. I had a DWI once where the dude actually didn't answer questions, didn't do field sobriety, and the blood couldn't come in because this was back in that weird time where none of the blood came in. And took the jury 3 hours and they finally acquitted it. They were mad at me for it. Like, I guess we had to. Well, they couldn't prove it, man. Like, he's not he's like, what do you want? Oh,
innocent until proven guilty is the thing, guys.
It is. It's so strange. This is random, but just for fun. Did you ever watch Better Call Saul?
Very few episodes. Don't hold it against me.
You should. It's just fantastic TV. And as far as realistic portrayals of how courtroom life is, they actually the series opens with him taking court appointments.
Oh, nice.
And just like not making ends meet, making it like the opening scene is him having 3 defendants who defiled a corpse in like a morgue.
Oh no.
And so he gives this grand closing statement, and then the prosecutor's just waiting. And then all the prosecutor gets up, he plugs the tape in, and it just shows them like drunkenly defiling the corpse, and they all go to jail as they should.
Yikes! Yeah.
And then he goes to cash in, and it was supposed to be like $800 for the trial. He goes, "It's 3 defendants, like it's 1 trial." So instead of $2,400, he gets $800, and that. So he builds into Saul Goodman, the character from Breaking Bad.
Yeah.
But there's a scene later when he's full Saul Goodman, and he's questioning a witness on a robbery. And it was just the cashier. He's the only witness. There's no cameras. But, I mean, the dude point blank, no mask. And he goes, all right, you sure that's the guy? You sure that's the guy? And he's pointing to the defendant at the table. He's pointing, that's your guy. And he goes, well, turns out you just pointed to a bartender in South Village. My client's actually in the back of the courtroom. He's not even sitting there. And of course, they declared a mistrial.
Oh no!
Yeah, but I mean, I say that to say
Totally not realistic.
it's not, but it's frustrating
Yeah.
because there is an innate bias from the guy sitting there. There's not much you can do
Correct.
about it,
Correct.
you know. But I mean, it does underscore a point of how eyewitness testimony works and bias towards, like, if you think that's the guy, how credible are you for the other one? I don't know what to do with that, but it's it's fun. Yeah. This case, we don't have that. He goes down.
No, we had a lot of evidence.
Yeah. You said this is the worst you've had. This happens. There are horrors in the world. Hopefully it's, I don't want to say rare.
I mean, I've seen a lot of bad things.
Yeah. Hopefully less common than the cases we talked about most of the day. People who struggle with drugs.
Yeah. I mean, a lot of criminal justice cases, there are people who make mistakes.
Yeah.
But there are people who do really awful, unspeakable things. And so, I mean, this one really got to me more than others. I think the pictures, I don't know. It was bad. And the other thing I guess we have not talked about is the system failed this child. The system failed Mercedes. And I fully believe that. And
when you say that, were there CPS calls before and nothing happened?
Katrina was under a CPS
safety plan?
Thank you.
So it hadn't reached court yet. It was a safety plan?
Correct.
Yeah.
And they were looking for her. They didn't know where she was because she left and went to Jose's house. Several neighbors called the police hearing the child get beat.
Jesus.
They never made contact. She was not in school. She was 5, so...
Kinder? Yeah.
Yeah, I mean, but really I think the biggest is the fact that the police were called several times and they never made contact. It was bad.
Did they go to the door and just not able to get in? And
Yeah, I just feel like it felt like she could have been saved, and she wasn't.
this gets hard. I get on a soapbox a fair bit because I'm on the other side of CPS. I'm not on the prosecution, the pro department side.
Right, and I'm going to say I'm not blaming anyone.
No. That's not the point.
Yeah.
You said it already. The system failed.
Jose and Katrina are to blame.
Absolutely.
No one else.
But we do have a responsibility collectively.
Correct.
And systems in place to do our best to avoid this. And I don't like the idea there was nothing we could do. I'm sure that's true in instances, but when you hear what you just said, there were police calls, CPS was already on it. I appreciate that's part of it because I'm pretty rough on cops, I'm pretty rough on prosecutors, and I'm pretty tough on CPS investigators that I think they overreach, overstep. I believe everything I say, but it's important, I think, to put the humanity to this is why some people are as aggressive or safekeeping as they are, because this stuff does happen.
Right, and that's what they're trying to prevent.
Yeah.
Most of them.
Right.
Most of them are trying to prevent the worst case scenario.
So if you're a judge in that, I mean, did punishment go to the court or to the jury?
Both. Katrina, it was to the judge because she pled, and then on Jose, it was to the jury.
I guess you might as well.
It was, I want to say 10 minutes on punishment.
Wow.
And came back with life. It was very quickly.
And how long was guilt innocence?
I want to say like 30 minutes. It was quick.
Yeah.
It wasn't long.
I mean, it was overwhelming evidence.
It was less than an hour.
It
was very quick.
That's tough.
Very quick.
Well, back to a prior point, and then we can have a little fun and wrap up. Your defense attorney you're appointed, how do you represent guys like that? I know the answer, but I think it's worth affirming. This guy's a monster. I mean, I don't know. He's a human being.
Absolutely. And as a defense attorney, it would be hard. It would be hard. I'm sure they struggled with it because obviously no one thinks that what this child went through was okay.
Yeah.
I mean, hopefully, right? Obviously, hopefully no one thinks that.
That's very fringe.
Yes. So, it's hard, but everyone deserves a good attorney to protect their constitutional rights. And that's the job that the defense attorney has to do is make sure that, he has a defense and that he's not, that he's getting a fair trial.
Yeah. It's still, you've not made this case to be clear, but the horror this girl endured and getting him behind bars still isn't worth shortcuts from the police, shortcuts in the grand jury's office, shortcuts in court, shortcuts by a judge making rulings they shouldn't, allowing evidence that shouldn't be there, inappropriate comments during trial, whatever they are. At the end of the day, the process is, in my opinion, more important than even a result as important as this. And that's hard to hear when you have this kind of case, right?
No, but it needs to be done correct. And I used to tell victims this, right? Like, we want, even as a prosecutor, and maybe this is me, but I don't know if all prosecutors feel this way, but as a prosecutor, I still wanted defendants, even Jose, to have a good defense attorney, because I want it done right the first time.
Yeah.
And if I am seeking justice, and that justice I believe is a conviction, which especially in this case, that is, I believe we got justice in this case, I want it to be done right so that it doesn't get erased and we have to start over and do it all over again.
She's referencing ineffective assistance of a counsel on appeal.
Yeah, or anything on appeal, right? We want it to stand on appeal. And that's something that a prosecutor has to consider throughout an entire case. And sometimes maybe they have to do both jobs. As a prosecutor, you have to also do a little bit of the defense work to make sure you're protecting your record and make sure you're protecting your conviction.
There's a really powerful moment that made the news. I think it was in Houston. I need to find the clip again. But a young woman was killed. She wasn't the target of like a drive-by shooting, but she wasn't the intended target, but she was killed in a drive-by shooting. It wasn't hard to trace the guy. Get him. He's not someone who can afford an attorney, gets appointed.
Sure.
And this court-appointed counsel doesn't show up, barely does anything, is barely doing anything. The victim's father was a relatively prominent attorney. And there's a very powerful moment where the victim's father is arguing to the court to replace counsel and get the guy representation.
Yeah.
And it was like, I was like crying, like, because your kid's killed. You don't want anything but horrors for the person who did it.
But you want it done right.
Done right, and
absolutely.
Hard to explain that. Again, I mean, I don't know how I would feel if I'm related to, what was the young girl's name? Mercedes, or I know her in any capacity. I don't have to know her to be outraged and be obvious, but but we need to be somewhat dispassionate to do our jobs correctly. Back to being a judge, it's got to be unpleasant, to say the least.
One thing, I don't know if you're asking me a question, but going back to what you were just saying, I almost am like, I don't know that man should have had to argue to get that counsel replaced. That is something that the judge should be, if the attorney's not showing up.
Absolutely.
That is on the judge to make sure that this defendant has counsel.
That's, I'm glad you said that, because it's, so the responsibilities of a judge, I'm going to say this and we'll decide where we want to cut it. It's not just a fun gig. It's not just job security. It's a great job, and it should be. I think the pay is okay. I don't know if the pay is what it should be, if I'm being honest. I think entry level is like 148 or 156 or something like that. It just went up. Okay, as it should. Yeah. And I don't want to say I feel like people do it for the job security, but I think there's a role people play for that. And it's a good gig. The requirements people don't know to be a judge, if I remember right, is a law license for 4 years and you won the election. Am I missing any?
Yes, it's changed.
Okay.
So it actually used to be, it used to be 5 years, not 4. It used to be 5 years.
5, okay.
And I think it still is for a misdemeanor judge, but for a felony, it's 8 now.
Okay. So for any district judge?
Correct.
Okay, because most districts, I didn't mean to make the distinction, but most district courts in our state handle civil, criminal, all of it.
Some do, right.
Yeah, we're unique-ish. Bigger counties do what we do, where it's separate.
Separate, Okay. It's 8 years, plus a law license.
Yeah.
And win an election.
So even at 8 years, you can be doing, and nothing against people who do this, insurance defense work, working at a desk, doing discovery on car wrecks, and win the election.
For a criminal bench and not have any experience and not know what you're doing.
Right.
Yes.
And
it happens.
It happens.
People run for benches they are not necessarily qualified for because they have the number of experience. Yes.
And so imagine, Judge Boyd, who I love because she went to LSU, or cheers for LSU. I don't know if she went, which big LSU.
I'm not sure.
Yeah. And I know she was a prosecutor a long time. I think she did both, if I remember
She did
right.
both.
She did both, yeah.
Mm-hmm.
So what Judge Boyd has to do in this case, one, whether there's arguments for bond conditions. They're still not convicted yet at the time.
Correct.
That matters.
It matters.
It's this woman's child. It's easy now, what a horrible person thrown into the jail, but you still have to consider bond conditions while this person's not proven guilty or innocent. Mm-hmm. That stuff's hard while there's pending family stuff. you've got to weigh the evidence in horrible trials. You still have to do it the right way. I think.
But you have to protect the community as well.
You've got to protect the community. But you got to do it fairly under the law. Yeah. You know, I think you said you guys got a search warrant for the phone.
Correct.
That requires all kinds of process, all kinds of specificity, whether it's legal, whether it's appropriate, has to be ruled upon correctly. Mm-hmm. And just because you want a result of this kind of horror doesn't mean you take shortcuts there.
Correct.
You've got to run a fair trial that's efficient.
Absolutely.
As far as the timing there, I mean, voir dire itself is a very difficult process to understand and do fairly. And now add on, you know, you're responsible. Attorneys are responsible for their own conduct, their own competence. But as a judge, I agree. To some degree, if you see something egregiously just gapped, I mean, I think it's your responsibility to a degree to protect that defendant. Like, what are you doing, you know?
Right.
Especially in court-appointed cases.
Sure. I don't necessarily think as far as if they aren't doing a good job, maybe in that judge's opinion, I don't think
Absolutely
you're not stepping in at that point.
Absolutely
right?
not, yeah.
But where, as you were describing in Houston, the attorney's not even showing up.
Right. Yeah.
Are they communicating with their client? Those are the two things the judge should be.
Absolutely.
Are you communicating with your client? Are you showing up to court? And
then, I mean, Matt, it gets hard because you and I both know. I don't know how you do it, but every criminal case I get, I don't even ask questions. There's a host of motions that get filed automatic in my office, like the Brady motions, some discovery motions, certain things like that. And then there's a list like almost preformed that when I tell the paralegal this is going, relatively almost form things we have to do. You know, I feel comfortable saying this. The idea that you show up, read the folder the DA has, read one report, and you take the plea offer, that's tough. That's tough for me to buy that you've done all the work you can.
Right.
I hate disparaging colleagues because I've done that before, and then I look back and like, did I really do the job I could have?
Right.
You know, really ask for the discovery, read the report, talk to your client, review the footage like you just said. Sometimes they mix up the people. Sure. Not nefariously, it happens. And you know, and imagine a case as significant as this. These two people are going to be in jail for basically the rest of their lives. Yes, as they should, but let's get it right. You know, what if it's the wrong Jose Ruiz? Or you don't know, whatever it was.
Right.
You know? Or what if it really was only Jose and not mom, or vice versa.
Right.
You know, so.
Right. Absolutely. That is something that, I mean, you're never really going to know. Right? Mm-hmm. And we tell this to jurors, right? The only way you're going to know 100% is if you were there.
I hate it when prosecutors say that.
It's true, though.
I hate it when prosecutors
Why? Say But it's the truth.
Yes, yeah. The what I lose my mind over is I've objected to this in every jury charge for every criminal trial I've had is when they do the burden of proof and they say reasonable doubt doesn't mean all possible doubt. I object to that sentence every single time.
It doesn't. And even as a defense attorney, I kind of get where you're coming from, but it doesn't.
Yeah.
And we don't have a legal definition of reasonable doubt, but
I always put up
it's not beyond all doubt.
Yeah. I put up clear and convincing has a definition, and it's higher than that. So I think it's a firm conviction or belief. Absolutely. It's higher than that, you know.
Right. It is.
And coupled with presumption
of
innocence.
It is the highest burden in the land.
It is. Yeah.
Absolutely.
Until you go on appeal, then it's just there is no chance. I'm just kidding.
But I'm going back to the only way you're going to know what happened is if you were there. So as a prosecutor or as a defense attorney, you're really never going to know the truth. You're going on what the evidence shows. You're going on, as a defense attorney, what your clients tell you, maybe what witnesses tell you, same as a prosecutor, you know. Yeah. And that's it. You have to trust that you are hopefully doing your job and finding out the truth, especially as a prosecutor. So you just have to try to be confident in what your decisions are.
This is the wrong case for this thing I want to say, but in cases of even like child abuse and stuff, there are other processes in place to give some like peace of mind to people. Like if you don't convict, you know, this woman was never getting her kids back, period. You know, so
if I'm not mistaken, she relinquished. But
she's going to jail forever. So yeah,
I think she relinquished before that.
Probably, yeah.
But yeah.
But you know, there's a process in place to terminate people's rights to protect kids too. So, and this doesn't mean don't prosecute. This means don't cheat prosecuting. Don't convict if you don't know, just because you want to protect the kids. There are other processes. Sometimes they fail. I mean, and I think you articulated that well. It failed here.
Both sides fail.
Yeah.
Right? Sometimes things don't work out as they should on the civil side, and sometimes they don't work out as they should on the criminal side.
Yeah.
But, I mean, maybe this might sound cheesy. I've always been a person who believes everything happens for a reason.
Yeah.
And maybe it just wasn't the right time, wasn't the right thing, but it, hopefully things get, solved or worked out in the end, I guess is what I want to say.
Obviously not for Mercedes, but,
Right.
for, I don't know if someone watching that or someone gets inspired to become a DA or a cop or a CPS worker because of it. Not that brings her back, obviously, but at least there. But yeah. But I'm glad thank you for doing that segment, and I know it's a hard case, but I do want people to get, you can do the hard stuff too.
Right.
Just because you're doing what I love your role as a judge, you also put someone away for life.
Right.
Who fucking deserved it. So, I mean, I think that's...
Yeah, and I think we kind of started to touch on this, but one of the reasons why I stayed on the case is because I didn't want to have other prosecutors have to look at the evidence that I looked at. And that was another thing too. When I left the office, because I actually left the DA's office before this case. Before this case went to trial, I left and I became a defense attorney. But I was able to be sworn in solely to prosecute this case.
Yeah.
And so I was actually a defense attorney when this case went to trial, but obviously in this trial, a prosecutor. And that was an interesting role, an interesting take. And I mean, I think it made me stronger on both sides, right? I think it was a good experience. It also was good closure for me, because to have to see stuff like this, we see some very horrible things, and we don't always get to see it through the end. And I actually prosecuted this one from start to finish, and that doesn't always happen, especially here in Bear County. And so it was a significant one. There's just, there's a handful that you'll never forget.
I'll put the links to some of the news articles you can read about it. I got to be special prosecutor once in a misdemeanor court.
Yeah.
What
kind of case?
As a DWI second.
That was your only prosecutorial experience,
my only
right?
prosecutorial experience. Judge Jason Wolf in County Court 2.
Okay.
With it. It's a second. I'm trying to remember. DWI. It was bad. It was BSU's ad. The woman was a nurse, the defendant.
That's hard, because then she can lose her license upon conviction as well.
I actually have lost sleep over what we ended up doing. Was like the world's worst probation.
Okay.
On a back when it was still obstruction.
Okay.
But it was like a max fine.
Wait, what do you mean? Is it not? There's still obstruction.
I think, but you can do deferred DWIs now.
Oh, yes.
Yeah. So before that statute changed.
What are you talking about?
Yeah. I protected her license, but I gave it was like the max 2 years for the whole fine, and was like doubled everything. Community service doubled everything. Yeah. There was a little issue with the blood, not much. I got good IPAC-ed, talked into it. I hope I did the right thing. I haven't followed up,
That's all you can do as a prosecutor is hope you did the right thing, right? And that's what prosecutors should be doing, is trying to do the right thing, no matter what.
Yeah. I will say, though, I'm very critical of DAs. I don't regret it, because you took the job. That is what it is, right? But I don't want the job. I'm good. I'm fine sitting in my little LSU den down here. So, yeah. Well, that was We Wrecked the Case. We always finish. I don't know if you've watched any of my little shows here. But
I haven't yet.
I know. That's okay.
Sorry.
No one else has either, so that's okay. I always finish. I call it Tiger Talk.
Yes.
Because I'm a big LSU fan. But it doesn't help that this past week LSU didn't play a game. So, yeah. But we did fire our coach in the meantime. So, yeah. So what we're going to do, coach, athletic director, and the LSU president were all gone in like a certain seam of time.
Okay.
Yeah.
Changes to be made.
Changes to be made. It's actually funny because at State College, Louisiana State University, the governor of the state actually has a role for a time when there's no president. It's random.
Okay.
Louisiana's great. We're corrupt.
Interesting.
But here, we'll flip it to, it's an off week for LSU, and the thought would be, how do you do self-care in general? This job, for different reasons between us, I don't want to equate them. I don't want to false equivalency, but the horrors you see, DA's office, you're on my side now a little bit, but things I see in family court, CPS stuff, or just the weight of people's lives, it's heavy. Yeah. Take it home with you. How do you manage that? And it's important because you're going to be a judge. You're going to see a lot more of it.
Yeah, I maybe good or bad, I don't know, but I kind of learned how to disassociate a long time ago in my career.
Hmm.
And I do my best to leave work at work, um, which is now a little hard since I sometimes work from home. But if I'm not working on work, I try to fully not think about work. It's hard sometimes.
Do you have a stop time? Do you have a? I know you're campaigning now, so pretend you're not campaigning. But is there a? It's 7. I'm done, or something
Um,
like that.
Sometimes, right? As defense attorneys, sometimes there are days where I'm working till 9 o'clock at night,
Yeah.
and there's some days I'm stop working at 3. Right? Like it's just it depends on my schedule, especially as a defense attorney. As a prosecutor, I probably worked harder than a lot of prosecutors. I would take intake home and work on intake.
Yeah.
And you don't get paid extra for that, right? Like a lot of prosecutors are the 9 to 5 or 8:30 to 5 or whatever it is, and that's it. But I would take cases and work on them at home. I don't know why I did that. I'm just a hard worker, but
Yeah.
I try. As I'm getting older, I try to make sure I don't overwork.
Well, I
If
mean,
that makes sense.
sounds like you work too hard. But what I will say is,
I'm a hard worker.
Your perspective doesn't seem to be tainted with cynicism that I've ever seen. Because I think that's 2 issues: cynicism and burnout.
Yeah, burnout's a real thing.
It is.
Yeah, I also try to take vacations. I take at least a vacation a year is my goal.
Good.
It doesn't always happen, but that's the goal.
Yeah.
And I mean a real vacation, not like I'm going to Dallas. But that's me. I read. I've gotten back into reading the past couple of years, and I read a lot. That helps kind of fully take your mind into another place, right? So that's good. And just rest, like sleep. I have 2 puppies. I love my puppies. They are what's the word? Very comforting. They bring me joy. There's nothing like having a dog.
We just got a new one. It's still peeing everywhere. It's a pain.
Oh, of course. Yeah. But they're so cute and they're sweet and they love you unconditionally.
Right. I'm going to convince you. Go to the gym. You will feel so much better.
I know that.
Yeah.
I know that. I know I need to work out.
I run my practice. I've got 4 kids, 2 stepkids.
I like my sleep too much to get up too early for that is a problem.
You will be floored at how you feel different.
I know. Yeah. I've done it. I've been there. I understand. I will make the commitment after campaign season is over.
Fair enough. There's always something else to do, though.
That's true. Yeah. I know. It's getting started is the hardest. 100%.
I think what I'll take away from this, though, is because, again, you can work hard and take your work home occasionally, but just, again, a focus does not be burned out. And whatever that is for you, whether it's your puppies, your reading,
right.
The vacation time.
Right.
I would guess it helps for you that you love what you do.
Yes.
So it's work, but it's not all the time when you're doing it.
Right.
It's fun.
I am very passionate about the law and justice.
Yeah.
And have been my entire career.
Okay. We'll close out. That wraps up another episode. A huge thank you to Marissa for your insight from the years of the courtroom and experience, prosecuting defense, and running for judge. Where can we find you personally for your law practice and your campaign?
So my law practice is justiceforsa.com, and it's all words spelled out. Mm-hmm.
FOUR, not or.
No, FOR.
FOR. Oh,
yes, justice for. SA. And
I don't know why I thought it would be FOUR. It's a long day.
That's okay. And then my campaign is marissaforddistrictjudge.com. I am also on social media. I'm on Facebook, TikTok, and Instagram. I want to say my TikTok is lawyer_justice4SA.
We'll make sure the links are on everything.
Yeah. But most of them you can find me under Marissa for District Judge or Marissa Giovenco. But my last name's complicated, hard to spell.
What else do you want to say about your campaign or yourself or anything before we?
I just want to say the election is in March of 2026 with early voting February 17th through the 27th. If anyone has any questions for me, anything they want to learn or want to know, if I can answer, I will. Please reach out. I would love to earn your vote in the primary in 2026.
To be clear, this is the Democratic primary.
Correct. The
Okay.
Democratic primary, yes, in February and March of 2026.
So you have to be registered Democrat to vote in the Democratic primary. Is that true?
You actually don't register with a party.
Okay.
But when you go to vote in the primary election, you have to tell them you want to vote in the Democratic primary.
Okay. Yeah.
Right.
And as of right now, you don't have a Republican opponent in
Correct.
this election, correct?
Correct.
So to vote for this court, you'd have to vote in the Democratic Party?
Absolutely correct.
Okay.
If I win the primary election, I would be on the ballot in November of 2026 as well. But as of right now, there is not a Republican opponent.
When's that deadline?
December 8th.
Oh, wow. Not much time, but still a month.
A month. Mm-hmm.
Yeah.
And you have to actually collect signatures and pay a filing fee. Like, it's not just something that you can do. Right. It's not. Yeah. So there's a process. So I'm hoping no one else files, but we'll see. We'll see.
Well, we got a big hurdle, and it's one opponent, Miss
Correct.
Anna, one more time?
Ochoa Nelson.
Ochoa Nelson. Okay. Thank you so much.
Yeah, thanks, Beau, for having me.
That's it for episode 6 of Fiegel Files. Thanks for tuning in. Stay tuned next week. Till then, hit subscribe so you don't miss an episode. Need a little help? Visit me at divorcelawyer.sa.com. Don't hire Marissa. She's too busy running for judge. I'm totally kidding. And follow me on all my social media platforms. Stay strong and go LSU Tigers against Bama this weekend.
All right. Thanks.
Thank you.
Well, that was fun, Beau.